My lords, with respect to this matter, it's a pollution matter, wherein it has been over a year since it is listed before this honorable court. A related matter is coming on the 15th, if it can be taken along with the same. A writ petition. Much obliged.
My lord, the writ was dismissed by the single bench. During the vacation bench, the vacation bench had awarded a limited interim order and posted the matter yesterday. It didn't come up yesterday, it didn't come up today. And the interim order is operating against me. Can I request for end of the day? Lordship. Can I request for end of the day, Lordship?
Interim order is expiring.
Interim order is acting against me. In fact, it was supposed to be listed yesterday. The interim order is now acting against me. I won in the writ. It was dismissed. Now I can't place the new contract because of the interim order and the project is stuck.
Supposed to be listed where?
Would Lordship kindly accommodate me end of the day, Lordship?
It was supposed to be listed.
Yesterday.
Before which court?
This honorable court only. It's a writ appeal, Lordship.
Supposed to be listed, then it will be listed again.
It hasn't been listed. In the High Court website, it is shown as yesterday, 6th. Not listed yesterday, not listed today either.
Pursue with the registry to be listed. If it is not listed within 2-3 days, then mention again.
Lordship.
Say that it is listed. If it is to be listed, it was to be listed yesterday.
Lordships.
Yes, madam. Yes.
My Lords, I wish to mention a fresh writ appeal. This is one concerning matter in the writ petition, my Lords. The matter was with respect to retirement ages. The impugned order challenged in the writ petition is one where retirement age was...
In respect of?
Retirement age of the employees, my Lords. The writ petition court has not considered my prayer for interim relief, and I have urgency as some of the employees are to be superannuated by the end of this month, my Lords, 22nd of January. Hence, I have filed a writ appeal challenging these orders by way of which my interim relief was not considered.
22nd January.
Lordships, my land is notified for the acquisition by the KDB Lordship. But my name is not reflected in the final notification. After lapse of 4 years, a KDB issued an endorsement stating that the acquisition proceedings are still pending. But award also not issued. Same has been challenged in the single bench Lordship. Already these matters are covered by your Lordship judgment Lordship. So, KDB acquisition Lordship matter.
Then there is no urgency.
There is a lapse in acquisition proceedings Lordship.
If it is covered, then where is the urgency?
Covered Lordships that has been dismissed by the single bench Lordship. That's why we have preferred an appeal.
So no urgency.
Lordship.
Let it come in regular course. You listed within 1 week. If it is.
Can I seek a date on Monday, Lordship, next month?
Office objection, remove the office objection, you listed.
Lordship, so we are compliant with the office's objection.
Then see that without memo it will list. No need to give memo.
There are similar matters, Lordship. There are 3 matters are there. Connected, similar matters. 3 similar matters are there.
Coming up when?
Lordship,
will
they are the
listed.
fresh matters which are filed by us.
If office will comply with, get it listed. No memo is necessary. It will list. Yes. Yes.
Your
Yes,
Lordship,
yes.
serial number 71, Your Lordship.
71.
Kindly have it on tomorrow, my lord.
Why?
Because another 2 I am for the respondent in this case. I am filed another 2 writ appeal. That writ appeal is tomorrow listed, my lord. That's the reason.
All right, tomorrow.
Please.
My lord.
Item number 63. 63.
You are party in person?
Yes. In person, I'm otherwise advocate.
63 is party in person? Yes.
Can be given the short date and top of the power? Can the
Shortest date is today.
Pardon?
Shortest date is today. Today you don't want to conduct.
No, yeah, because the number is far off.
How can you say at 11 that?
Okay,
Ah,
wait.
Serial, I have 23. I'm appearing for Jalakumar. Yeah, kindly, for Jalakumar, there is an issue. Kindly 10 days time may be granted, madam. I have informed the council also.
why do you want time? Why do you want?
The council on record is not well.
Council is not. At the request of learned advisor of the appellant on the ground that the senior counsel who is to conduct the appeal is not is in indisposed health, stand over to 20th February.
Lordship on submission,
Yes.
serial number 20. The
Serial number-
challenge, serial number 20, my lordship, 20.
Yes.
The order under challenge might be complied anytime soon, so the contempt may not arise. Kindly have it of 2 weeks, my lord. We'll apprise the court.
You are for?
I'm for the petitioner.
When do you want? 3rd March, as requested by learner of the complainant. Yes.
My lord, in this case, the petitioner,
Right.
despite of several attempts, she hasn't received the convocation certificate from KSOU. Writ petition was filed and the order was given, and on top of that, the writ appeal was filed and it was dismissed because it was not maintainable. She's facing a lot of trouble continuing with the profession because she doesn't have the convocation certificate, my lord.
Okay. Twentieth January.
28. Please.
Can you mention through VC, sir? Kind permission. Contempt matters, seal number 1. Mr. Naveen Chandran.
Lords, in this, we have filed a compliance affidavit and they have challenged that endorsement in writ petition, my lords.
You
The
already-
application,
Already tell.
Yes,
application has been
in
rejected.
writ petition number 19645 of 2024, the endorsement that has been issued has been challenged by the complainant.
My application has been considered and rejected, my lords. Hence, this petition wouldn't survive for consideration. I may kindly be reserved with the liberty to challenge for the.
It is already challenged. That is what the learned AGB says. GP says.
This petition wouldn't survive for consideration.
This petition, learned so and so fairly stated that the present contempt petition will not survive as the endorsement is already issued by the competent authority. In light of the directions issued by learned single judge, learned additional government advocates, additionally states that the said endorsement is also challenged by the petitioner complainant by filing writ petition number 19645 of 20. Dismissed as not survival. This petition is dismissed as not survival.
Seal number 2.
Appearing for complaint. In this case, my lord, the petitioner filed complaint before the police and the police has filed charge sheet against the respondents, accused persons here in Malad. They said charge sheet was challenged by the respondent before the Sam Court Malad. The Sam Court Malad allowed the petition and directed to release the articles in favor of the respondents Malad. Thereafter Malad, after getting the order Malad, I have filed application for modification of the order Malad. The Sam Court Malad directed the trial court. The petitioner is directed to make an application for conducting inquiry and to get the articles released. Your lordship kindly turn to page number, the ink page number 37, operative portion of the order at ink page number 38, my lord. Right. May I read, my lord? After disposal of the petition, an application filed.
Committed contempt.
Please, my lord.
Which authority has committed contempt?
My lord, complaint was filed by the petitioner.
Which authority has committed contempt?
My lord, respond number 1 to 3, my lord. They made application to release the application, release the articles in favor of respond number 1, my lord. Particular contempt committed by respond number 1, my lord. But all of them jointly filed application before the trial court to release the article despite there being an order passed by the Sam Court.
There is no direction against number 1.
Please, my lord, your lordship can turn to page number, ink page number 38. It is however, my lord, in the final order dated 3/7/24, the articles to which husband has no objection ordered to be returned to the wife, and since the items seized from the other and other items were ordered to return to him. It is however now sought for by the wife that an inquiry should be conducted regarding the ownership of these articles Since the proceedings itself have been closed, the question of holding an inquiry by the magistrate would not arise. It is however to be noticed that admittedly there are two matrimonial cases pending. One for dissolution of marriage by way of divorce in MC 3165 filed by the husband, and another case in MC 7357 of 23 for restitution of conjugal rights filed by the. In view of the pendants, it is open for the wife to raise claim regarding these articles, which are the subject matter of the application in the above mentioned case, and establishing that the said articles belongs to her.
Here also there is no direction.
My lord, that my lord, the sum and substance of this observation, my lord, that I have to make an application.
Authorization doesn't make out.
My lord, he cannot file application to release the articles when there is a specific direction to conduct inquiry.
That direction to release the article.
But that has been modified by this way, my lord.
They approach the magistrate.
My lord, they can't take my lord, we have approached the magistrate. Magistrate has released the articles in favor of husband. That is my question, my lord.
Not contempt. There is
My
no-
lord, they by mislead this finding and get it released by producing this order, they have got it released, my lord.
Of the contempt jurisdiction, there has to be a positive direction against.
My lord, positive direction, my lord, the trial court is directed to conduct inquiry.
Inquiry
my lord,
is not conducted.
inquiry is not conducted.
What inquiry?
Therefore, my lord, now without conducting inquiry, now the articles have been released. When the court has been specifically directed to to decide the title of the articles before the competent court, which are pending before that, how can the magistrate, how can the respondent number one make an application to release the articles? He can't.
In this petition, contempt of court is alleged by the petitioner in respect of the directions contained in order dated 3rd July 2024, passed by a single judge in the criminal petition number 10161 of 21, read with order dated 21st August 24, passed in IA number 1 of 24, full stop. In the first order, in the first mentioned order dated 3rd July 24, comma,
Page 24, my lord.
the directions contained, the observations, the order or the operative order reads as an, and quote paragraph 24 on page 24. Full stop. The direction doesn't apply to the private respondents arraigned herein as party, alleging contempt against them. As far as order dated 21st August 24 is concerned, as far as order dated 21st August 24 passed in the interim application is concerned, the only observation is made, is that it will be open for the wife to raise a claim regarding articles which are subject to the application in the cases mentioned in the paragraph. Full stop. Paragraph. In the text of the case and in the nature of the orders which are brought under contempt jurisdiction, comma. It cannot be said that any contempt is committed by any of the respondents. Full stop. The remedy of the petitioner complainant is not of filing the contempt petition, but to approach the competent forum by instituting appropriate proceedings in accordance with this.
And if that application is filed, let it come expeditiously.
Is not entertainable, it is dismissed accordingly.
My lord, one submission, my lord. If such an application is filed, let it be considered expeditiously, my lord.
That is
Since-
not the domain of this contempt jurisdiction.
Please, my lord.
Yes. Seal number 3. Mahesh Sharp.
Right, as per the order passed by the honorable court, operative portion is not at the ink page 22 and 23. I have deposited, but now as per class 3, but I have deposited 7 lakh.
Khata is issued or not?
Please, no?
E-Khata is issued,
Not
notice,
issued.
notice returnable. It was stated that the last directions in the operative order is for instance of E-Khata, which is not complied with, supposed to be in that view. Notice returnable on 3rd August, 3rd March.
Number 4.
Appear
HIB.
petitioner, my lord. Lord, petitioner, my lord, had deposited a sum of 54 lakhs with BWSSB, my lord, to obtain permission to develop the lands. My lord, the builder could not go ahead with it, my lord, and the joint development was cancelled. An application was made seeking refund of that money, my lord, which BWSSB did not refund.
What were your representations?
My lord, representation to refund the deposit what we made to BWSSB.
Deposit.
Yes, my lord.
Notice returnable on 25th of February.
Much obliged, my lord.
Number 5. MJ Alva.
The order is non-complied, the lordship will find it an actually A, page 18, my lord. The grant was made in lieu of the lost land in the Hemavati Reservoir project. Then, my lord, that order was challenged before the learned single judge. Learned single judge quashed that order and directed the authorities to restore the revenue entries. That has not been complied hitherto.
3rd March, notice.
In all these 11 contempt petitions, well, are same identical case.
Serial number
All
15.
three, same 3rd March. Yes,
15.
up to 7.
15.
8.
15.
Sorry, up to 15.
Number 16. Rohit R. Kumar. 16. Rohit R. Kumar.
Pass over, next.
Number 17.
That's the order of the single judge, Manoj, is at page 13, Manoj. Manoj, the order which was passed by the first respondent authority, Manoj, was set aside, Manoj, by the learned single judge, Manoj. And the matter was remitted, Manoj, for passing fresh orders, Manoj. However, Manoj, till today, Manoj, there is no order passed by the first respondent authority, Manoj.
Passed by Assistant Commissioner. It was remanded to whom? Assistant, but no time.
Assistant Commissioner, Manoj.
The operative order passed by a single judge. The operative part of the order dated 20th September 23, passed by a single judge. Under the contempt jurisdiction, reads as in the 4th paragraph 5 on page 28. So on a after reporting on bare reading of the aforesaid direction, it could be immediately seen that though the sole on a single judge has directed the assistant commissioner to reconsider the matter, no time limit is fixed, full stop. In that view, it cannot be said for the present that any of the respondent, and in particular, respondent to assistant commissioner has committed any contempt of court, much less a willful contempt. At the same time, the order of the court should not go paragraph. At the same time, the order of the court should not go uncomplied with. Therefore, it is provided that the assistant commissioner respondent to herein shall comply with the directions by deciding the matter within 12 weeks from today, telling which the authority shall be exposed to the contempt jurisdiction.
Great.
Petition is disposed of accordingly.
Number 18. Narsimha Raju. Number 18.
Pass over.
Number 19. A.V. Gangadharappa.
Nobody is there. Pass over.
20 urgent. Number 21.
That's
20 is
that's-
adjourned. 20 is adjourned.
21.
Petitioners, Manoj. Manoj, the petitioners, Manoj, were terminated from service, Manoj, which order was challenged, Manoj, before the learned single judge, Manoj. If your lordship kindly peruse page 26, Manoj. Para 9, Manoj, of the order, Manoj.
Page 26.
Page 26, Manoj. Para 9, Manoj, last 2 lines, Manoj. Respondent number 1 is directed to continue the petitioners on daily wages basis as scavengers till regular recruitment is made, and also to provide petitioners opportunity to participate in the regular recruitment process. This order, my lords, was challenged by the government, my lords, in a writ appeal, my lords, which was dismissed, my lords, by this honorable court, my lord. However, my lords, till today, my lords, in spite of representations, my lords, being made by the petitioner,
What happened to writ appeal?
writ appeal is dismissed, my lord. If your lordship kindly peruse page 32, my lord,
Dismissed.
dismissed, my lord.
So what is that writ appeal? Any modification in the order?
There is no modification, my lords. The order of the learned single judge, my lords, is confirmed, my lord. At page 32, my lord.
So today you are not in service?
I have not been continued, my lords, in service, my lord, by the respondent authorities, my lord.
On a single judge. Is order dated 13th December 22. Directed Respondent One Commissioner, Hindu Religious Institution and Charitable Endowment Department, Bengaluru, to continue the petitioners, thus the complainant's hearing on daily wage basis as scavengers till the regular recruitment is undertaken. It is also provided that the petitioners shall have opportunity to participate in the regular recruitment process. This order passed in the writ appeal number, writ petition number 8873 of 21 came to be confirmed by the division bench in the writ appeal number 459 of 2023, division bench of this side. It was submitted by learned advocate Pereira for the complaint, Mr. So-and-so, that notwithstanding the above, the petitioners, the complainants are not continued in
Please,
service, and the breach is committed of the direction of learned single judge, confirmed as above. Pereira, notice returnable on 13th February.
Great.
13-2. So green bench matters, seal number 22.
I'm appearing for the petitioner,
Done.
your lordship. On the last occasion, the respondents were directed to file their objection. This matter pertains to transfer of funds by the District Mineral Foundation from one district to another district, your lordship.
We are not interfering in this matter.
Your lordship, the issue, your lordship, here is that the
Any
central government.
statutory infraction,
Yes,
any statutory infraction.
yes,
It-
your lordship.
What?
The central government directions are violated when the transfer of funds is to be done by one district to another district, your lordship.
Central government says that yes, our directions are violated, we'll issue notice. Yes.
The central government.
According to us, there is no violation.
My
According to us,
lord,
there is no violation.
my lord, let there be a verification by the C&AG, your lordship, because C&AG is an independent authority. This is what the PM's scheme guidelines state. I would, my lord, to refer to page 86, your lordship. There is the PM scheme where it is the clear scheme is provided. The future funds are asked to be transferred to the extent of 28% from one district to another district, which is in gross violation of the scheme, your lordship. The scheme starts from the central government scheme starts from page 71, your lordship. Central government clearly states that this has to be used by a specific requirement, and page 84, which I had read the last time, your lordship, clearly restrict the transfer of funds from one DMF of the district to another DMF, your lordship. Page 84, I would read, your lordship. Para 6, your lordship. Restriction on fund transfer from DMF. In respect of DMF funds of the district, your lordship, the subparagraph 1, the provisions of section 9B of the act shall be strictly adhered to in respect of the utilization of funds by the District Mineral Foundation. There is a clear guidelines by the central government, your lord. No fund shall be transferred in any manner from the District Mineral Foundation to the state exchequer or state level fund by whatever name called, or Chief Minister's Relief Fund or any other funds or scheme, and no sanction or approval of any expenditure out of the funds of the District Mineral Foundation shall be done at the state level by the state government or any state level agency. No fund shall be spent outside directly or indirectly affected areas within a district or for other than affected people as defined in section 1.1. The subclause 5, your lordship. No fund shall be transferred in any manner from one district to another district except as mentioned in section 2D. Your lordship, this situation does not arise, 2D does not arise in this fact situation, your lordship.
Sorry, heard learned advocate Mr. So-and-so, so-and-so for the petitioner and learned additional Solicitor General Sir Arvind Kamath, assisted by learned advocate Ms. Anupama Hegade for the respondent number 1 Union of India, as well as learned additional government advocate.
On respondents 2 to 5, my lord.
2, 3 and 4. Upon service of copy of the 2, 3 and 5 upon service of the copy of the petition in advance. The present petition is styled as public interest petition. Post of the petitioner is stated to be a non-profit organization in the name of women and rural people of Sandur Taluka, which has moved this court through its president to submit that Discount Union of India has floated a scheme on 16/9/15 in the name of Pradhan Mantri Khanij Kshetra Kalyan Yojana, whereby a district mineral foundation is established in every district in the country, which is affected by the mining related operation. Full stop. Certain funds are earmarked for the purpose under the scheme. The grievance paragraph stated in nutshell, sought to be raised in the petition is that the state of Karnataka, government of Karnataka, by notification dated 8/2/21, established new Vijayanagar district by carving out 6 talukas out of Bellary district, and that the newly established Vijayanagar district consists of 6 talukas. It is the grievance that the authorities have diverted the fund from the aforementioned Yojana which are otherwise were supposed to be used for Bellary district to the Vijayanagar district, and that such transfer of fund is to the extent of 28%. Full stop. It is the grievance that the transfer of fund is not permitted under the scheme, and that the public interest is suffered thereby. Full stop.
Lordship, the future funds, Your Lordship, that the transfer of funds at the future date, Your Lordship, it is ad nauseam. It can, every month it has to be transferred. That is the difficult, that is the abject violation, Your
Transfer
Lordship.
of fund is contemplated periodically.
It's at Annexure H, Your Lordship, that the direction of the state government is dated 10/7/2024, which is after the central government devises the scheme.
Not only that, the petitioner is not able to establish any statutory right and public or statutory infraction to found its case and grievance so as to invoke the jurisdiction of this court, the allocation of fund under the scheme is best left to the authorities concerned. Full stop. It can be such matters which are purely to be measured by the criteria to be adopted by the competent authorities, cannot become subject matter of public interest litigation. The court is not inclined to exercise the public interest litigation, which is invoked under Article 226 of the Constitution. Petition is meritless and dismissed.
Yes, 23 is urgent. Number 24. Mr. Prakash, let's see. 24.
You are there, madam?
Respondent number 5.
My lord, appear for respondent number 10. A short passover, my lord.
So what is the suit? What is the suit pending? 85 of 85? What is that civil suit pending?
The section issued by the appellate authority, Taluka executive officer, to
If
register.
you don't
annex
know
the-
about the civil suit pending, then let the petitioner come.
Yes.
Pass it out.
Please. Yes.
Number 25.
I pay for the
Sudhindra.
petitioner in this case. In pursuance of the order passed by this honorable court, a commissioner was appointed and commissioner has submitted the report. That report is in Kannada, my lord. No English translation is not there. So the government has to file an English translation.
Heard, my lord, on 2 occasions wherein they are challenging, my lord, the grant of quarry lease in favor of respondents 7 and 8. only on the simple, my lord, ground that there is a hillock where there is a deity, and that deity has been shifted to another village so that a temple
That's
can be
not the
constructed.
only point.
My lord may see the prayer. That is all that there is.
No,
to
no,
it.
no, no, that is not,
Washing of the.
it's all right. If translation is not required, I am prepared to argue.
Required for all this. My lord,
Alright.
hear this matter. I have filed my statement.
Respondent number 6 and 7, they have filed the statement, not permit, I think. Lord, anyway, if it is not required, I am prepared to argue.
Pardon?
If the translation is there, it will be very convenient for me to convince your lordships. Because it is in Kannada, that report submitted by the commissioner who has inspected this spot and
If I understand the matter, then I'll understand the Kannada.
then it's okay, my lord. Then it's okay. I cannot.
Which translation is not provided, Mr.?
Please, my lord.
Translation of which part is not provided?
And this report, which the commissioner has submitted, it is,
Which is part of the.
it is like this, my lord.
My lord, I had filed.
Kannada.
Along with documents.
This has to be translated copy has to be filed. Lord, by the specific order of this honorable court, the commissioner was appointed and the commissioner has submitted the report.
My lord, translated copy is produced at page 16 of that memo.
16 of the memo.
It is not served on us.
Very.
It is not served on us. How can it be?
Yes.
Memo is dated 19/8/2024.
19/8/20. It is not there possible. The reply is there, but memo doesn't appear to.
My lord, I filed it in the office on 20th August 2024.
No copy is served. Is there? Not served. Time for consolation. I'm just filing points for that arise for the consideration of this honorable court. This time filing.
If you really want time,
Please.
if you want time, then you have to find out a new ground.
No, I see. If it is there, I will have a look and make submission. Because each and every aspect has been dealt by the commissioner about the distance between the area which has been granted.
Do you think that this is single judge bench?
Lord,
my brother knows the Kannada.
Yes, my lord knows very well. I know. My lord very well knows. Lord, just I am
No. There is nothing in it. Oh, you want to argue, then argue.
Yes, I am permitted to file the points that arise for the consideration.
On the contrary, there is a
My lord,
something about the petitioner or conduct of the.
My lord, what has happened is everything has started. There was an order passed by this honorable court. Your lords may kindly take annexure. Annexure C, ink page 28. Lord, several matters had come up before this honorable court, and in the nature of writ of mandamus, they had sought for the relief. My lord, the respondents who have secured the quarrying lease, they are the petitioners in WP number 17387 to 17388 of 2018. Your lordship gets it at page 29 of the petition.
What is this tank? Some tank is
My lord?
the
Tank.
Tank, my lord, collection of
Tank is at
water.
just 108.
So they are not touching the tank.
No,
They are not touching the tank.
No, no, my contention is every drop of rainwater falling on this small Karab Gutta, it is being collected in the tank. The entire surrounding lands are depending upon the tank because that is the source of water where the borewells are recharged. That is not the only point, my lord. Lord, survey number 31 of Mudgurki village, it is a Goma land. So this is popularly called as Karagadammana Gudda. It's a deity called Karagadamma. Translated copy, Commissioner report, English translated copy, government report. ಕೊಡು.
ಇಲ್ಲ ಮಾಡಿರೋದಿಲ್ಲ ಮಾಡಿ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಆ ಥರ ಅನ್ನಿಸಿದ್ದೀನಿ ಏನು ಮಾಡ್ಬೇಕು
Yes, anything further?
Please, may I just draw your lordship's kind attention to Rule 6, Sub-Rule 2 of KMMC Rules 1994. May I submit? Sub-Rule 2.
ಬೇರೆ ಗವರ್ಮೆಂಟ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟ್ ಮಾಡ್ಬೋದು ಬಟ್ ನಾನು ಆ ಥರ ಮಾಡಲ್ಲ. ಮಾಡಿ ತಗೊಂಡ್ಬೋದು. ಕನ್ನಡನಲ್ಲಿ ಓದಿ
What is the mining lease that has been granted to mine which product?
Millard, for these building stones.
Building stones.
Building stones.
Now, according to you,
Millard,
they have not taken into consideration the
Millard,
existence.
the first
One sec,
point,
one
yes,
sec.
please.
According to your writ petition, they have not taken into consideration the existence of a temple, number one.
Yes.
Number two, existence of a tank.
Yes.
Number three, existence of a gomal area, which the surrounding villages utilize to graze the cattle.
Yes.
And existence of a cart road.
Yes.
That's all.
Yes.
That's all.
That apart. That apart. Rule 2 of Sub-Rule 6.
No.
I have
Factually speaking, these are the four aspects.
No, I have filed the amended petition. In the amendment, after amendment, I have sought several other grounds. Apart from that, Rule 2 of Sub-Rule 2 of Rule 6, it says, no person shall carry on or allowed to carry on any quarrying operations within a distance of 50 meters if no blasting is involved, and 200 meters if blasting is involved from the boundary of any railway line, reservoir, tank bund. So, according to the commissioner report, the tank is at the distance of he is at the distance of 108 meters. 108 meters. This is one point. Secondly, the matter is not placed before the task force committee before grant of quarrying lease. What has happened was in WP 17387 to 17388 of 2018.
Which is your amended petition?
Please, my lord, amended petition I have filed along with the application. I have filed certain documents also. Amended petition is also filed, my lord, on 14th August 2024, I have filed the amended petition. Lord, let me take Lord's kind attention to this aspect, because along with the amended petition, I had produced certain documents. Before that, let me take your Lordship's kind attention to the order passed by this Honorable Court in WP 17-387-388 and other connected matters. May I just, your Lordship may kindly take page 40. Annexure C, page 40. Lord, this Honorable Court has passed the order directing the authorities to consider their applications in accordance with law after getting the opinions from the authorities. What the authorities have done, they are quoting the order of this Honorable Court as if this Honorable Court has directed them to grant the NOC and grant the acquiring lease. That is how the tenor of their orders speak like that. Your Lordship may kindly peruse page 40. Page 40. Having regard to the submissions made, the petition stands disposed of at this stage itself, while requiring that the concerned authority shall send their views, opinions to the authorities of the Mines and Geology Department within 2 weeks from today. The authorities concerned shall consider and finally decide on the prayer of the writ petitioner for execution of the lease deed within 4 weeks from the date of the production of the certified copy of this order. So at page 41, same thing. Lord, this is the order. So for this, now the authorities, what they have done is, the Lord may kindly take the annexure K, which I have produced along with the amended petition, along with the application. You are for whom?
I am for respondent number 7 and 8, contesting, please.
7 and 8.
Please.
Very good, amended petition. Same. Yes, annexure K, page 14 may kindly be taken. Translated copy. This matter requires reconsideration by the authorities, my lord.
Today this something is submitted is not part of it.
Yes. My lord, in the annexure K, this is the translated copy of the order passed by the Assistant Director of Mines. What they say is, accordingly, as per the orders of the Honorable High Court of Karnataka, the Divisional Commissioner of Dodballapura has issued no objection certificate with regard to quarry land as per reference number 5. In that connection, the applicant has filed the request before the head office to take necessary action as per the orders passed by the Honorable High Court of Karnataka. In that connection, necessary action has to be taken as per reference number 6. Lost. Therefore, the order passed by this Honorable Court of Karnataka is attached along with this letter by mentioning that Tejas, proprietor of TGK Enterprises, application for sanctioning the quarrying license is not considered as per Rule B2 D of KMMRC Amended Act 2016. Further, it is observed as not to face the contempt proceedings before the High Court of Karnataka. Under the apprehension of that, the petitioner, the person who has filed the writ petition would file the contempt proceedings. They have given blanket permissions without application of mind. These things are not placed before the task force committee as per the rule. As per rule 8B1D, 8B1D, D1. It is mandatory. Joint inspection is mandatory. And the matter has to place before the task force committee is mandatory. Without doing all these formalities, straight away they have granted quarrying lease. How can they do that? Not it's a serious matter.
My lord, please see the rule, sub-rule 6, my lord. If the deputy, may I read? If the deputy commissioner or the assistant commissioner of the revenue department, rule 8.6, page 35. Or the deputy conservator of forests or the assistant commissioner or the deputy director or senior geologist, as the case may be, fails to give no objection certificate or joint inspection report under sub-rule 5 within 90 days from the date of communication, the same shall be placed before the district task force mines committee in its monthly meeting by the concerned deputy director or senior geologist. Here they have received the no NOCs. So the question of placing it before that doesn't arise.
No, my lord, that is not correct because rule 8B1D, it is mandatory on the part of the authorities to place the matter before the task force committee before grant.
See, counsel, on facts, you are required to establish that he is not entitled for mining lease.
Yes.
You have raised 4 grounds on facts.
Yes.
That's all. You have said there is a temple, there is a tank,
Yes.
there's a cart road,
Yes.
and it's a Goman land.
Yes.
Now, you are required to state the existence of a temple or a tank or a cart road
Yes.
or Goman land prohibits the state government from issuing such a license.
Lord, I am a
Okay. And you are also required to state.
Yes.
Now, if it is at what distance it can be granted.
Yes.
Okay. This is all your
Yes,
cases.
yes, your lordship is
If you
100%
make out a ground on these
Right.
points, you have a case. If you don't, it will be dismissed.
Yes. Lord, I'm just filing additional documents, photographs. Copy. My lord, the inspection report applied area for quarrying lease in this. Next page.
You have to show it in reference to government documents, sir.
Please. My lord, I have produced the photographs. Some photographer, please. My lord. Photographs I have produced showing the existence of tank when tank was having water.
All that will consider. Or learned.
No, your lord, they still have little more submissions.
We are not deciding. Yes. Yes, what do you?
Lord, Annexure K and Annexure L. Lord, Annexure L I have produced. Here also, this is the Assistant Director of Department of Mines and Geology, Office of the Director of Mines. Lord, in page 18, what they say is, applicants also filed WP number 17387 to 17388 of 2018 seeking direction to consider their application for obtaining quarrying license from the state government. Say Honorable Court passed the order dated 2/7/2018, thereby directing the concerned authority to obtain opinion within 2 weeks and thereby directed to sanction the building quarrying license within 4 weeks. Lord, this Honorable Court has not directed them to sanction. Consider the case on merits, apply their mind. They have not applied their mind. Lord, therefore, as per the orders of the Honorable High Court of Karnataka to issue stone quarry license, hereby kindly obtain appropriate NOC from the concerned department. How can they misconstrue the order passed by this Honorable Court, my Lord? They have to apply their mind. That is one aspect. Lord, another aspect in the forum, yes, which they have said, if any objections are received by the public, forthwith the quarry license will be withdrawn. This is what they say. And there are so many, and the way, the court way. Now your Lordship could see the photographs which I have produced.
So heard learned advocate Mr. So-and-so, senior advocate Mr. So-and-so, assisted by learned advocate for the petitioner and learned.
With my one submission.
Want to submit?
One submission. As the learned court pointed out, there are 4 consideration place, my lords. The government order is in my objections. At page 106 is the Akar Bandh. Akar Bandh would be, what is the nature of the land in that survey number?
106.
106 of my objections.
106 of the compilation.
Of my objections, please. Objection of R7 and 8.
This is your objection, bigger than the petition.
Please, the fatter one. Page 106, please. Translated. It says there are 30 acres, 22 guntas in that survey number. All of it is a B Karab land. B Karab land would include, my lords, it is not fit for any agricultural purpose. It is completely rocky farm.
That comes somewhere.
Please, my lords.
That comes somewhere in your reply.
106.
It's your reply?
My objections, 106, please. It's a translated copy.
You have not filed reply.
I have filed my objections, my lord. My lord, we have filed it on 21/10/2019. Along with that, my lord, I have filed memo with the documents on 19/8/2024. We have disputed this.
Yes.
Page 106, please, my lords, is the Akar Bandh. It says that there are 30 acres, 22 guntas in this land, which is completely B Karab land, which is rocky formation. It is not fit for, my lords, grazing land also. As the learned court pointed out, whether it is a Gomala land that is grazing land, it cannot be a grazing land. Now, page number 107, it is the Kannada copy. It may be read, page number 109 and 110. 110 is the translated copy, please, my lords. 110 says, this survey number, which is 30 acre 22 guntas, was previously mined by 10 people. 10 mining lease was granted between the year 1997 to 2003. And the map is at page 109.
None of the quarrying leases have been carried out because of the objections raised by the local public.
I may be permitted. Page 109, my lords, is the map. Translated copy, page 110. Translated copy of page 107. Totally 10 mines have been worked prior to me.
10 or 12?
12, including me. Now, 10 prior to me.
10 prior to
10 prior to me. Including me, 12. Mines have worked, which shows that it is an area which is completely rocky formation where DMG can provide mines. Subsequently, my lords, once these mines were, this mining lease was granted.
All those leases have been cancelled.
Is expired, please, my lords, it says. Once, my lords, these mining lease was granted, my lords, they have to fix coordinates. Those are latitude and longitude coordinates. At that juncture, we provided a drone survey of the entire hillock. There was no temple, nor there was any deity, etc. But subsequently, they started putting statues there, saying that there is deity. We approached this honorable court and obtained an interim order at page number 287. After obtaining page 288 is the interim order, subsequent to which they were still in
280,
288,
18,
288, 288,
18,
288,
288.
8. And the respondents were none other than the petitioners here. Subsequently,
The petition defendants in that suit.
there the defendants, some of the petitioners are there.
It is a writ petition, not suit.
GMCPC matters under order 39 rule 2, it's appealable order. That's
That
why.
is pending or disposal?
It's pending, please, my lords.
Pending.
Pending. And subsequently, though such being the case, there was interference. We caused a notice to be issued to the SP. Notice was issued to the SP, and subsequently, my lords, somewhere around 4 FIRs were registered against them.
That you have stated.
Please. And now this we have got to know, please, my lords, that an FIR is registered by the Anti-Corruption Bureau, now undertaken by the Lokayukta, stating that there has been illegal occupation of land.
By petitioners.
Illegal occupation of land. And page 356 and 358, please. These are the maps which shows that there exists a road only for transportation of the minerals, which minor mineral which are mined there, which they have closed it off by the photos which is at page 354. And subsequently, please, my lords, were pleased to ask that with respect to, my lords, their tank, they themselves read out the provisions. Within 50 meters, 50 meters, blasting should not be allowed. Ours is 108 meters. We are not undertaking blasting. Blasting permission is not given to us. Neither explosive permission is given, license is given to us. It is 108 meters over and above it can be granted, but blasting permission should not be granted. We are not blasting, please. These are the 4 millets we have addressed.
One fact I would like to bring, because my lord asked me the question about the tank. My lord, as per the commissioner's report, tank, apart from the tank, Beediganalli ಊರಿಗೆ ಹೋಗುವ ಕಾಲುದಾರಿ ಇರುತ್ತೆ 17. Point number 17 pointed out by the commissioner. My lord, that is the answer the question posed by your lordship, my lord. Whether the existence of road is there or not. It is there. The commissioner has pointed out that. And entire surrounding lands are grape garden lands and other agriculture crops are grown. If quarrying operations are there, the dust and particles of the stone particles depositing on the leaves of the crops, it destroy the whole system. This is not a good place for quarrying a lease, and let the authorities reconsider the matter. Because just because there is a direction by the Honorable High Court of Karnataka, we are obeying. That is the tenor. Lord, let this matter be reconsidered by the authorities. That itself is sufficient.
Assisted by learned
Yes.
advocate Ms. So-and-so, from a learned additional government advocate for this one state. Its authorities and this one, and learned advocate Mr.
Bharat Kumar, please.
Bharat Kumar with 7 and 8.
Please.
7 and 8, at length, at length. Paragraph. Learned advocate party stated that the bleedings are completed, no further are required to be added or supplemented, reserved for hours.
Obliged.
Much obliged.
Still number 26. S.Y. Shivalli.
For the petition, this matter, the matter pertaining to not laterite. Laterite, according to me, is a minor mineral which has been declared by the central government of by its notification of the year 2018 itself. Not this matter was not argued by senior counsel several times. Learned Front took time. They want to place arguments. If they are ready today, not the kind.
Will have to be re-argued.
Sorry,
Matter relates to challenge to certain entries, my lord, to the Karnataka Mines and Minerals Concession Rules, my lord. The licenses.
May I submit, my lords? I am for 26-123, my lords. Here in the small issue is that according to the respondent state, it is bauxite, which should be leviable royalty at that rate. Whereas our contention is that it is a minor mineral and royalty is payable as per schedule.
You want to argue, then start arguing.
Yes, my lord. May I submit, my lord?
My lord.
Mine is a earlier filed writ petition, my
Weeks
lord.
accommodation may be considered.
What is it? Beg your pardon?
Weeks accommodation.
No, I think my lease is going to expire within next 8 days, my lords. 18th is the last date. That is the lease deed, my lords. Because on several occasions, matter has been submitted, argued, and for one or the other reasons, it could not reach a finality. And all pleadings are over. Only short bit, and even I made a submission. I am willing to pay the double the rate of royalty fixed in the schedule, as subject to the results of the writ petition.
Only have it on Monday, my lord. 15th, my lord, I'll go ahead.
Please, ma'am.
Monday will take it.
Please, my lord.
3 matters. Are there? How many?
Well, they are connected 3 matters.
3.
This is number 27. Chidanandaya.
My lord, I appear for respondents. My lord, on 19/6/2024, my lord had directed me to place on record by way of affidavit the progress of the survey. My lord, to verify whether the land for which the application is filed is a deemed forest or not. My lord, this morning I have received the information. My lord would grant me some time, my lord.
Not only a written the nature of mandamus, your lordships. Their own survey says it's a patta land, your lordships. Annexure F. Last time also I pointed out that.
Cell wants to put some relevant material on record.
No, I have to obey my lord's order. I cannot disobey it.
Stand over to, in view of request made by learned additional government advocate, who wants to place on record the stand of the authorities by filing certain documents, stand over to 23rd January.
Obliged.
This is number 28. Mr. Amritesh. 28.
You are there in 28.
My lord, in this I'll file my objections, my lord.
I am for the 5th respondent.
What if they want to demolish some taluka building?
Yes, my lord, because they have constructed, my lord, a DC building at the back. My lord, the petitioner who claims to be the president of the Udupi Bar Association, my lord, seeks as a matter of right to demolish this building, which is 25 years old, so that they can be parking, my lord. According to him, this building looks ugly because it is in front of this.
But you have constructed new building?
Yes.
At the back, we have constructed a new building. The front building, we are using it to my lord, house other government
There is a
offices.
report of my lord, the surveyor, my lord says that my lord, the building, my lord, the existing old building, my lord, is in habitable condition. My lord, there will be, my lord, lost to the government if, my lord, if demolition, my lord, is made to them. It cannot be demolished. There is.
Let the petition.
Please.
Pass.
Would it be called next week, my lord? Meanwhile, my lord, we'll file our objections. We have not filed our objections, my lord, meanwhile.
Let the petition.
Please.
This is number 29. Manish Shankar. Petitioner, my lord. Yes, I have given a representation before the respond number 2 to 4 to take action against illegal trespassers and unauthorized persons putting a compound wall in survey number 57, 58, 60 in Majare Vasalli village, Raspa Obli, Durbalapur Taluk. So, but
your application or representation is pending, page 43. To the made to Tehsildar, Uddavallapura Taluka, Bangalore Rural. Pursue that.
Pending.
So pursue that, we'll ask them to consider. Lord Learned Advocate Mr. So-and-so over the petition. And Learned Additional Government Advocate Timothy Nilopar who appears upon service of notice by this court. The present is a petition styled as public interest litigation. By the two petitioners who claim to be the public spirited persons. The grievance of the petitioner's paragraph is in respect of certain alleged unauthorized encroachment on the government Promotional land by unknown persons. It is stated that in survey number 7, land measuring 6 acres in Karnataka, which is a land situated at Majra, Sahalli, Kasba Hobli, Doddaballapura Taluka, is a government land. The petitioner have produced the extract of RTC in seeking to substantiate the award. It is stated that certain unknown persons have trespassed the said property and has put up compound wall. And they have also cut the standing trees. With such basic premise pleaded. It is stated that the representations dated 26 to 24, 28 to 24, and 29 to 24 are already made to respondent 2 and 4 by the petitioners. However, they are not attended to. With such basic premise of facts, the petitioners are afraid to direct the respondents to decide the said representations and pass applicable orders. Also, in view of the said prayer, which is the only prayer made in the petition, and in the totality of facts and circumstances, the only relief to be granted in the petition is to require the competent authority of the respondents to look into the representations of the petitioners pending with them, made as aforesaid, and decide the same in accordance with law and on merits. Also, the decision which may be taken, which shall be done within 12 weeks from today, shall be communicated to the petitioner.
Obliged, my lord.
is disposed of and not entertained. Full stop. It is clarified that before that, it is clarified that this court has not gone into the merits of the case of the either side, paragraph. This petition is accordingly not entertained, subject to above limited observation.
Much of. Yes. Seal number 30. Shrimati Saraswati M.
But in this matter, I seek some small accommodation, my lord. I have been, small accommodation, my lord, I request, my lord.
This is that marriage certificate by Waqf.
Yes, my lord, I need
Lord,
some.
File your reply.
No, my lord, I pray for some time.
My lord,
Decision
I pay for the third respondent, my lord. My name is not shown, my lord. Kindly direct
The
the
counsel is
office.
appearing for
P. Usman.
parties pray for time. Send over to when shall we?
10 days, my-
10,
I just filed wakalat, my lord.
19th of, let it be on 6th, 10th of February, please. 10th of February.
obliged.
My lord, the third respondent, I have filed wakalat, my
So the
lord.
next date, the pleading shall be completed, including the reply from the respondents. Full stop. Name of learned advocate,
P.
Mr.
Usman.
P. Usmani,
Yes, my lord. For,
who appears for
respondent number 3, my lord, the Waqf board.
and whose file wakalatnama shall be indicated on the board while notifying the petition.
Yes. Seal number 31. Ravindra Gajan Pillai.
Please, my lords. I have applied for the grant of a quarry lease to extract grey granite on 14th August 2014. And subsequently, revenue NOC, forest NOC, and technical report were received prior to 12/8/2016. Hence, this has been considered as a saved application. With all that, the quarry lease ought to have been granted, but under a mistaken impression, this declined by way of an order produced at Annexure C.
You need to file your reply. Reply shall be filed before the next date, put upon
Please, my lords.
11th of February.
Please, madam.
Number 32. Mr. NP Amrutesh. 32. The PA.
Appear for respondent number 5, my lord. I'll file my reply, 2 weeks accommodation. I
Lord,
served
yes.
copies in the last week.
No,
There
let-
may be seen, my lord.
Let the petitioner come.
Appear for respondent
You have
5.
to be the judge of your own matter in which you appeal. Otherwise, no matter will be. All right. If the petition makes out a strong case, you file reply.
Please.
Right? Keep passing over.
Yes. Number 33. Sir Shivaldi.
Lord, I'm appearing for the petitioner.
Similar matters are decided.
No, my lord.
Similar matter decided.
Hmm.
Lordships
My
have
lord,
decided.
notices have been issued levying penalty.
That is my impression that notices are for penalty
Yes, my lord, for
without.
illegally quarrying building stone, my lord, to the tune of nearly 71,844
not
metric
heard.
ton.
Exactly not identical.
Oh, exactly. That is
That
what
is
my
WP number
critical.
32953.
And the penalty is not, there is no process of assessment of the penalty.
Exactly same.
And there is no
Notice
hearing
also.
given.
Same dated notice. Same dated notice, Lord, A2/2024, in all these writ petitions.
It shall be treated as
Show cause notice. And permitted me to file a reply. And
My
then
lord,
uh,
here, my lord, the
And it-
inspection was, notices had been issued to them, which they themselves have produced,
Here it is.
to show that, my lord, informing them, my lord will get it at
This office notice. This office notice, 8/3/20.
Page number 70 is the implement notice.
That we have seen.
Translated page number is 72.
72.
72.
Translated.
My lord, please see page 75. the notice dated 7/3/2024.
That is different purpose.
No, no, you were aware of the proceedings. That is what I'm trying to submit.
Improved notice dated A2/2024 is challenged in the present writ petition, Lord. And based on this notice, Lord, they forwarded this, Lord, forward to the Tahsildar Mudeba to recover the penalty amount of rupees 2 crore 51 lakhs as a arrears of land.
So drone survey was conducted, you are directed to present personally.
My lord, there's no cooperation from his side. And thereafter, when the notice was issued, my lord, calling upon him to file a reply for the penalty that is being imposed, no reply. My lord, no reply. Thereafter, this penalty was, the notice is issued fixing the penalty. My lord, they were aware of the proceedings. It's not that, my lord, principles of natural justice had been violated or that they had not been heard.
Provision of law under which penalty has been issued, Madam. Government advocate,
My lord,
provision of law on which penalty has been imposed and how you have come to such an assessment, how you have made that assessment.
my lord, based
You have not made assessment.
for 71 lakhs. Then may I make one?
Process of assessment is not reflected any.
That my lord had observed in the previous proceedings also.
Ah.
My lord, may I make one submission? My lord, let at least 50% be deposited before my lord.
In wake of these similar orders, otherwise we.
My lord, at least some amount, my lord, because the quantum is 71,000, 1 lakh, 2,000 metric ton. My lord, this will, otherwise, my lord, this will encourage the quarry owners to, my lord, indulge in illegal quarrying.
But a similar writ petition, the 32953,
But here.
the very same writ petition.
The council is right to the extent that there was some intimation, some notice of the.
No, my lord, no, none of the notices are served upon them, upon the
You
petitioner.
knew that process to start.
Kindly, my lord, this is
The amount now you are demanding.
in this
My lord, in the first one, it is 2 crores 51 lakhs.
2 crore 51 lakhs.
In the second one, it is 3 crores 78 lakhs. Because the quantum is 1 lakh 8,099 metric ton. And
There
in
is
the
no
other, it
application
is
of mine.
3 lakhs and it is 10 lakhs 69,000.
In all these cases,
69 lakhs 15,000.
in all these cases, Lord, they randomly they fix the amount without Lord assessing Lord, the quantity which has been extracted and transported. And behind the back of the petitioners, they have not the assess this, not and impose the fine amount of rupees 2 crore, 3 crore, and 10 crore like that. There is no notice, there is no opportunity of hearing. That's a clear case of principles of natural violation of principles of natural justice. Now, following the same lordships, very same notice was challenged in WP number 32953, wherein lordships have considered and disposed of, considering the very notice as a show cause notice and permitted me to file a reply. And thereafter, they have been directed to take notice, take decision. This is the very identical writ petition, Lord. These three are also similar writ petitions. In all the writ petitions, the very same notice is involved, A2/2024.
Yes. So here also drone survey was conducted.
All cases are similar, identical.
Notice is closed, it shall be treated as a so-called notice. Permitted to file reply. The details from the. Same lines, please. Follow this.
All the three are similar.
All
All-
three, all.
Obliged.
Before 36.
Number 36. P. Dhananjay.
Yes. Yes, what is it?
I sought for the compensation, my lord, the
Pardon?
early hearing also filed, my lord, earlier occasion.
Hmm?
Earlier occasion, I also filed the early hearing matter, my lord. Kindly directly dispose the matter.
Lord, there was a direction, Lord, to the KDB to, Lord, consider the representation of the petitioner and, Lord, release the compensation. Lord, will comply, Lord, will comply, Lord, will comply.
Complied with.
We're not yet compliant, Lord, will comply, Lord.
When?
Lord, week's time may be granted, Lord.
At least a date may be fixed, my lord, to comply the order.
You record the statement. And if you are satisfied with the statement, dispose of also. It is a payment of compensation.
Payment of compensation.
Day after tomorrow. The complaint is going, undergoing the surgery, my lord, that is the relation.
So it is not,
Medical
provided you establish that you are the sole and absolute owner of the property. No other rival claimants, the amount shall be released in petition. It is the following directions which are made subject matter of alleged non-compliance by filing this contempt petition. So page 9, you got bracketed portion, the petition is given liberty. Today when the contempt petition paragraph after quoting, today when the contempt petition comes up for consideration, learned and educated Mr.
HL Pradeep Kumar. HL Pradeep Kumar.
So and so appearing for respond number 2.
2, Lord. 2 and 3.
See you, my lord.
The direction is to, Lord, 3, respond number 3.
3.
You are for 3.
3. Both, Lord, 2 and 3. Lord, 2 is, there's no direction.
Officer 2, KIADB, into Metro, made a statement before the court that the compliance of the directions is under process.
Please,
and that the directions shall be completed within 2 weeks from today. In that view, dispose of?
Dispose.
Dispose of, full stop. The above statement satisfies the learned advocate for the petitioner, Mr. So and so, paragraph. The respondent number 3 is directed to comply with the statement made before the court. On failing with, the authority concerned shall be exposed to the aggravated form of contempt.
Next matter is also same. Next
Lord,
matter.
submission, Lord, and instruction it could.
Next matter is also same order.
37 also same.
Both, yes, next.
December.
Do it, otherwise again, he has to come again. You are just to verify the ownership and decide whether compensation is to be paid. If it is to be paid, then pay it. Yes.
December 38. So PL Mr. Sunil Kumar H.
Petitioner, my lord. Lord, in this petition, my lord, the petitioner has sought for the compensation and rehabilitation for the farmers, my lord, who have suffered landslides and they have lost their houses and farms. And lordship has issued notice and, my lord, pleadings are not complete. If they file the objections, my lord, lordship may hear it out.
My lord, I seek for some time, my lord, it's coming up after.
More than 300 families were affected. The government itself came with a proposal that they have to be relocated. They lost their lands and cattle also. Lord, some rehabilitation and compensation needs to be given. That's the only prayer that is sought, my lord. Once the pleadings are complete, my lord, we'll just.
They have not paid anything.
No, my lord. And now they are many of the farmers are in makeshift houses. And there is already a regular threat that there may be heavy rainfall also.
But have they framed any scheme for compensation?
No, my lord. Now the
the deputy commissioner has also requested that he has framed one scheme under which 15 lakhs rupees can be given and they can be relocated to a different place, which is geologically safe, so that there may not be further landslide in the future.
That amount is given to you or not?
No, not given to us also. It is still pending with the deputy commissioner. So the government has to take a decision whether
And
where
I'll take instructions.
10 or 20th February,
Obliged.
20th.
Please, madam. Great.
Obliged.
10 down to 20th February in order to enable additional government advocates, Srimati Neelo Akbar, to take instructions in relation to the subject matter grievance.
Please, great.
December 39.
Take over.
Rahul S. Reddy.
Well, that's appear for the petitioners in this matter.
5 and 6.
What is it?
My lords, may recollect this matter, my lords. This is a public interest litigation. Seeking a direction, my lords, to safeguard the property which was gifted to the school way back in the year 1956 by one Mr. Pattabhirama. On 26/5/1956, my lords, at Annexure A, page number 33. Annexure A, page 32, my lords.
This was argued.
Yes, my lords, this was argued.
Yes, what is it about?
At page 32, my lords, Annexure A, this is a gift deed of the year, my lords.
15 guntas of a playground is now sought to be purchased by respondents 5 and 6. My lord, and now they are constructing a house there. My lord, according to us, my lord, it was a gift that was given to us by one Pattabhirama Rao, not to the Maharaja, who in turn handed it over to the Deputy Commissioner Revenue. Now, the contention of the respondents 5 and 6 is the gift is not complete because it was not accepted by the DC. My lord, and they are proceeding for construction. They say they have filed a suit for declaration, possession, and permanent injunction and have obtained an order. But however, in the said suit, my lord, the government has not been made a party. The children are deprived of a playground, my lord, measuring 15 guntas. And the sale deeds that they are relying upon, my lord, doesn't trace the title of the property, my lord. That is the beauty of the sale deeds which they are relying upon. The sale deeds do not trace the marketable title. My lord may take annexure E, page 57, paragraph 2. The vendor and the purchaser's particulars are given, and how this property came to the vendor is not mentioned. But straight away it says that whereas due to our urgency in meeting our family expenditure, the scheduled property has been hereby sold by us. Same in the sale deed at page 69. And by virtue of this, on the strength of this judgment and decree, now they are trying to put up construction.
May make submission. And file the memo with the document in the earlier suit, entire proceedings.
Yes. The petition number 3, Choda Reddy.
Yes, ma'am. He is one of the witness
Yes,
in OS number
yes.
and he deposed of, and also petition number 1 is none other than relative of the defendant number 6.
Brother-in-law,
Yes, ma'am.
correct.
Now the suit is adjudicated and declared in favor of the respondent number 4 and 5. 5 and 6, my
So
lord.
this petition number 3, Choda Reddy is deposing that I submit that 7197-3
Yes, ma'am.
was not utilized by the government
Yes, ma'am.
for any public purpose.
Yes, ma'am.
Defendants, plaintiff number 2, and other are in possession of personal. And I also put up construction.
And now you can give the coloring a PIL after defeated the original.
This deposition is contrary to your case in.
Yes, ma'am. Again, I produced the
My
entire
lords.
written statement and the document in OS proceedings, my lord. Even written statement also, they have taken the contents.
Lords, it is our contention. If I may permit to submit. my lord.
Kindly turn page number 13, para B, my lord. Written statement filed by the defendants.
Government, according to you, in the year 1956, the land was donated in favor of the state, right?
Please, ma'am.
Huh? And state is the owner of the property.
Yes.
Please, ma'am.
And you are not a party to the proceedings in the original suit.
No, we were not aware at all till this judgment and decree is produced before my
The
lord.
revenue documents stand in the name of the government.
No, ma'am.
Please, my lords.
The revenue
Yes, my
documents,
lords.
that is the RTC or Kata, whatever.
My lords,
That I'll verify and make a submission because I don't want to make submission of the
Careful.
cup.
No, I am
my lords,
produced the entire.
Annexure A is the gift deed, my lords. After the gift deed is executed, my lords, the RTC extracts and the revenue records have been changed in the name of the government, my lords. Now, my lords, it is later on, the respondent number 3 and 4 who claim to be a class 2 legal heirs of the donor. They, my lords, they have executed a gift deed in favor of respondent number 5. 5, my lords, in turn has sold 50% of the property to respondent number 6, poor husband and wife. Now, my lords, the respondent number 5 and 6, they claim, my lords, they are the owners of this property and my lords are encroaching the school property. That is the respondent number 2. This public interest litigation is, my lords, only with respect to the school property. Let the school property be enjoyed by the second respondent.
My lord, in any document of conveyance, my lord, usually the title is traced. The very fact that the title is not traced in these sale deeds in which the respondents 5 and 6 are relying upon speaks volumes. Now, this is an interstate dispute between petitioner number 3 in the writ petition and the respondents, my lord, 5 and 6. Fact remains that it is a government land. 15 my lord, guntas is used as a playground for the children coming to the primary school. My lords will have to protect us.
Kindly the document number 28, page number 28, document number 7.
Why did they not make the government a party, my lord, knowing fully well?
Take instruction.
My lord, technical
Even
issue.
even last date of also the direction is given to the
My
government.
lord, it's
to
a
ascertain.
technical, that is why, my lord, I'm stuck now. The very fact, my lord, that we were the government primary school is not made a party. My lord, behind the back, my lord, this is done.
The
Now suddenly out of the blue, they start
government-
construction, children are deprived. My lord will have to save us because the little ones are not able to, my lord, run around in that 15 guntas.
Now kindly
Fact,
peruse
my
the
lords,
gift deed, please.
one of the respondent is an employee in the school. Knowing the background of the
Jeez.
gift deed, this fraud has been played, my lords.
120.
Now there are 3 properties involved in the gift deed, my lord. Now the PWD office is constructed in the very same property, and also other encroachers also constructed the house, but they have not claimed the entire property. There they have only restricted 30 guntas only.
We keep it on 21st. No, 20th. One sec. 20th is which one? We keep it on 21st. 21st.
Oblige.
Date ಮೇಲೆ date.
Obliged.
ಮಚ್ಚ.
This is number 40. Sharath is Zoda.
Appear for the complaint. But the direction of the learned single judge, my lord, was to effect podi and durast. Page 17, my lords. My lords, last occasion, if your lordship recollects, my lords, they had issued an endorsement stating that there is some resistance from the local villagers. Therefore, they are unable to conduct podi. Your lordship instructed them that cannot be the objections. They'll have to take police protection and do it.
My lords, we took the police protection and we tried to do the survey, my lords. Again, once again, even the complainant was present at the Mahajar. The nice, my lords, they have raised an objection that it is their property. Now, complainant, my lords, it's supposed to be a grant land. They should be in cultivation and they should be in possession of the land, but they're not able to identify their own land. This is the
That
problem.
is the reason we
So
have sought for
tried to
podi.
do the survey, my lords, your lordship may see the Mahajar. The complainant was present. The nice KIDB has raised an objection. So
copy is
we are
given.
going to include them as a party. They say it is their land.
Include them and as a party and do it.
We'll do that, my lords. We'll fix a date and do it. Please take the call.
In fact, my lords, the very petition was that, because this is the second round of litigation, my lords. In the first round of litigation, my lords, after this court directed for a mandamus to effect podi, they issued a frivolous endorsement
Let
stating
them
this comes within
identify
the.
their land, my lords. We will conduct.
Let-
They are ready to
Let
do
all the
survey and
interested party, including KIDB and NICE, be made as
their
parties.
land, they should be aware where they're cultivating.
We are
where they're
unable
in
to locate
possession.
it. That's the
They're
reason
not
we have
able
sought
to
for
locate
podi
the
and
land,
durast.
my lords.
What does it say?
My lords, we went for survey, my lords. The complainant also was present among other people. And it says that when we started doing the survey, the nice, that is Nandi infrastructure corridor, my lords, though they say that the land was given to them by KIDB and it is a part of, portion of it is their land. So they want to also be a part of the survey. So we will again, once again, now, my lords, we will include them and then conduct the survey. That is all.
We have no objection, my lord, to include NICE as well as KIDB and conduct survey.
To include?
NICE as
Give
well as
them notice.
KIADB, Karnataka Industrial Area Development Board, as well as Nandi Infrastructure Corridor Enterprise Limited.
Trust, corridor, enterprises.
All that we want to know is to identify our land so that we will come to know. If our land comes within the acquired portion, we can at least approach NICE and get compensation. If it comes outside it, we will use it to our best of the.
So you put this on record and also undertake press exercise.
Very well.
Grant 2 weeks.
My lords, 3 weeks.
My lords, if your lordship, my lords, may I request your lordship to say that let them conduct survey by giving, by notifying NICE as well as KIDB also, my lords. That puts the rest to the
Then
list, my
3-4
lords.
weeks time may be granted. We'll issue notice to them and conduct survey.
NICE is also party in the writ petition. If your lordship sees, my lords, 7, 6, 7, 8 and 9, they are the parties. Therefore, now government, my lords, as if they cannot come before this honorable court in contempt jurisdiction and say as if they were unaware of this. In fact, they were the parties to the original writ petition. If your lordship takes the original writ petition order, page 14, and page 6 to, and respondent number 6 to 9 are this KIADB, Special and Acquisition Officer KIDB, Nandi Infrastructure Corridor Enterprises Limited, Nandi Economic Corridor Enterprises Limited. They were the parties.
So they
Therefore,
are-
I am not asking for a survey in their absence.
They are not made parties in the contempt, so it was well and good if
Why
the
will I make
complainant
contempt
can
will
be.
be, my lords, in contempt, the accused person is the only person who has disobeyed the order of this honorable court. NICE is a private person. I cannot make NICE as an accused to this contempt jurisdiction. It is their duty to give notice to all the interested persons and conduct survey. And contempt, my lords, is filed on 1/2/2024. They take notice and issue a frivolous endorsement that some local villagers are obstructing. For that, your lordship instructed, take police protection and do it. Now, my lords, today, after your lordship instruction, they come and say NICE is objecting. What is this, my lords? This is a case of aggravated contempt and shows helplessness of the state and how some private persons are behind these respondent attack accused persons.
Order dated 3rd November 22, which is brought under the contempt jurisdiction from a learned additional government advocate, agreed and committed before the court that the officials will be instructed to accomplish the task of conducting 4D endurance work as was done in the other accompanying cases of writ petition number 36954 of 17, 36955 of 17, and 5626 of 2021. Today, when the petition comes up, contempt petition comes up for consideration, learned the additional government advocate Srimati Nalin Pramodinication submitted that the officials had went to the site and the measure was drawn.
Please.
On which date?
6th January.
6/1/2025, on which date they say that some.
Yesterday.
Yes, my lords.
6th
Look at this.
January 2025. In which process the complainant petitioner was present. Full stop. It is the say of the respondents through learned additional government advocate that the petitioner is not able to identify
Please.
land. Therefore, the exercise could not yield the result.
My lords, that
My
is
lords,
not the endorsement, my
my
lord.
lords,
They say.
It says
They endorse the measures inter-alia states. Don't write that. That the that the officials of KIDBA and NIC are present,
Please.
who stated that the land belongs to.
that it is a part of it is also theirs.
Part of it.
That the part of the land belongs to them. Pereira. In light of the above aspects developed in the process, Pereira, learned advocate, learned additional government advocate would submitted that the authorities proposes to conduct fresh
Please.
survey of the land of the petitioner by formally issuing notice to the NIC and KIDBA.
Please.
It was stated that the petitioner shall also be invited. Full stop. Full stop. As such, the measure dated 6/1/25 records that it is resolved to conduct survey of the land by involving the petitioner, NICE and KIDB.
Please.
Full stop. Aforesaid exercise period shall be completed within 3 weeks.
4 weeks, my lords.
Not 4 weeks.
Your lordship may kindly see their conduct. Your lordship, last order is, yesterday they go to do the master.
3 weeks, 3 weeks.
Obliged.
3 weeks. Petitioner shall cooperate.
Please, my
Most of these contempt petitions shall be next listed on 3rd February.
Grateful, lords.
Obliged.
Bill number 41, Chandranath Tarika K.
Here for the complaining. My lord, in this, I would seek for 10 days accommodation for
4th February.
please.
Number 42.
I appear for respondent.
May I seek a pass over, Lordship?
Why?
For the past.
Then some other day?
Only request is the father is wanting to see the child, Lordship. through
Well,
video
the
call.
matter is pending in the guardianship of family court. He has made
Correct.
an application there and the order is reserved on 24.
Correct, Your Lordship. The
I don't
matter
know
is
why he
pending
is
before the trial
proceeding.
court. Trial court has passed an order saying that father should be allowed to speak to the children for 10 minutes through video call. Even that is being not been granted by the respondent. The
That
whole
is not,
content-
that's not correct, my lord. He has made an application and the order is reserved for 24. The matter was referred to mediation. He refused to come. He said, I'm not attending the mediation.
Lordship, there is a history to this case. Since 2023, the father is being not been allowed to speak to his children. I had to come to this honorable court, file a habeas corpus.
Pass it over.
Yes, my lord, senior is engaged. Just to see the children, allowed to see the children, that's
We'll
it.
see who done now.
Please, grateful, Lord.
Pass it over.
Great.
43 to Omkar.
So here we have complied with the order passed by this honorable court by registering the sales certificate. That's it is called the filing of sales certificate. We have produced the encumbrance.
If I'm
certificate
permitted,
also.
my lord, they were bound to register the certificate under Rule 17, Part 3A, my lord. Whereas, my lord, they have undertaken to do the filing under Rule 17, Subclause 2, Subclause 3 of the Karnataka registration rules. My lord, with respect to this, my lord, it is the, my lord, therefore, my lord, in view of the said fact, my lord, the order is not complied. That the sub-registrar was bound to make entry of the sale certificate under Part 3A, my lord.
That is not the part of the direction of law and civil law.
My lord, in fact, their compliance affidavit in itself, my lord, states the same. Kindly, my lord, I may be permitted to draw the attention of this court. Lord, to paragraph number 4 and paragraph number 5 of their compliance affidavit, my lord. If I'm permitted to read out the same, my
It is
lord.
the fact that we have registered under 17 Part 3. Lords, as claimed by them, sale certificate has to be registered under 17 Part 3A. But then the software is not yet developed. It is under development, my lords. That is what we have stated. Therefore, in order to comply, we have registered in 17 Part 3 and issued the encumbrance also shows that the sale certificate is filed, my lords, that is registered. I've produced the section, I mean the Act book also, my lords, at Annexure R1, page 5, which clearly says that that it has to be registered under Part 3A. But since the software is under development, wherein we have stated in our affidavit, my lords, that it is under development, we have registered so, my lords.
If I'm permitted, my lord, even as per their compliance affidavit, they state that they will comply with the same by the end of January, my lord, at paragraph number 5. Kindly, my lord, a date may be fixed, my lord, to that effect.
We have only stated that it is to be launched by end of January.
It's your lookout.
Please.
It is your lookout. You can't put them into hardship for that.
My lords, but we have registered. Unless the software is ready, my lords, we are not in a
No,
position.
you are required to develop the software. That cannot be a ground for.
My lords, may kindly give me 2 months' time, and then we will, once the software is ready, we will also.
If I'm permitted, my lord, this is the predicament of
But
every.
there is no willful disobedience, my lords. We have in fact registered following the orders of the court. Whatever was available for us in that mode, we have registered, and we have produced the encumbrance certificate also.
If I'm permitted to make the submission,
The lordship may observe that once the software is ready, we will register once again with 17(3)A also, my lords.
if I'm permitted, make the submission, my lord. This is the predicament that is every single auction purchaser, lord, is compelled to undergo. Lord, the law provides for registration without entry of the sale certificate, my lord. The sub-registrar and the concerned department, my lord, without developing the software, a lot of auction purchasers, my lord, are compelled
Lords, the software, unless it is developed, my lords. Therefore, we have shown our compliance, my lords, by registering in the other option. And we will undertake to register once
See,
it is ready also.
Government advocate, you need to understand, in the sub-registrar's office, certain documents are stored in certain books. Correct? Certain documents are stored in certain books for a particular purpose.
Please.
Now, it is your responsibility to develop your software accordingly. If you commit that mistake, tomorrow when they want to alienate the property, when it goes for legal scrutiny, there will be certain issues. They will have a problem in further alienation of the property. Tomorrow, some DC will come up and urge that it is a fraud. We are seeing it happening in your grant certificates.
That is the crux.
Therefore, my lords, are making this submission. Once immediately the software is ready, then we will also do it. Apart from this, we will do it in that particular manner which is prescribed.
Tell us that it is being undertaken. The process at least you commence.
Lords, that is why I have produced the correspondence, my lords, the letter also, that Center for Smart Governance. Therefore, I produce annexure R4.
What is that? R4.
The correspondence.
What is this?
My instructions are, it is in book 1, which will later, even in 17(3)(a) also, it will be in book 1. But only the provision is different, my lords, what we have registered. And he undertakes that in case the software is ready immediately, it will be done even under 17(3)(a).
So according to it, can be registered as part 3A.
No, my lord. My lord, this predicament, my lord, I am an auction purchaser, my lord. I have participated in the public auction. In fact, my lord, this aspect does not just simply affect me, my lord. Every single auction purchaser is put through the very same hardship. Now, my lord, subsequently, because of this discrepancy, my lord, despite me purchasing the property upon paying the lawful consideration, my title is not perfected. Lord, by virtue of this flaw, my lord, a lot of auction purchasers are now, my lord, compelled to get the registration of the sale certificate by paying stamp duty, my lord. The state, my lord, does not seem to be interested in developing the requisite software, only because, my lord, in the absence of the same, a lot of auction purchasers, without having any option, my lord, are paying hefty stamp duty to the state and getting the sale certificate registered only to secure their lawful interest. Lord, in such an event, my lord, the state must take up some measures. With some timeline will have to be stipulated, but lord, I
Kindly see
cannot.
page 38 of the order, what it says. It is in favor of the petitioners in book 1 only. We have done it in book 1.
That can't be accepted. Do it in book 1 means book 1, the relevant provision.
We just find out.
Please.
February.
Grateful.
This is number 44. With the Nisha S. Kumar, party in person.
Lordship, just to give a little gist of the case, there was an order from the Honorable High Court in granting me permission to reside in the matrimonial, in the relocated house that was offered by accused number 1, that is my husband. In the DV proceedings, he had offered to relocate me from the matrimonial house, which was granted under the DV Act, to move to a relocated house, which is a 1 BHK in the same premise. And he had promised the court that it was going to be fully furnished with all the amenities as well as water connection and generator connection. My Lordship, if you may kindly take it to page number 94. I have produced the photographs he has produced before the trial court, which shows the fully 1 BHK house fully furnished. He has even given a work memo along with his application for modification, which is at page number 90. If I may kindly take you to page number 90, my Lordship, is the work memo produced by him before the trial court, giving a description of all the amenities and all the furniture that he's going to provide me. And he's produced almost 40 photographs to that extent to convince the court that he's providing me all these amenities, all the furnitures. But when the order of the High Court granted me permission to get access to that house, he has taken off all the furniture off. He has even damaged the water connection to that place. To that extent, he has even gone ahead and got his cousins to come and stay on my property, vandalized my property and illegally entered my premise and sit in there, and threatened me by filing a false complaint against me. Now, for the last 13 years, I've been left homeless. I'm running all the way from Bombay to Mangalore for every case hearing. I have ended up paralysis because of this harassment.
Yes. Let's, can I request Lord to please not turn to Lord's order dated 1/10/2024, my Lord. 1/10/2024, my Lord's order, my Lord. Was the only requirement that she had sought for was not, there was no water in the premises. Kindly see my Lord's order. 1/10/2024, my Lord. My Lord's order.
Report was obtained.
But the report was obtained and Lord, then Lord, the panchayat was asked to be made a party for water connection. Because there was no water connection obtained to the premises. And Lord, panchayat has now Lord just served a copy Lord of the affidavit that they have now filed. The panchayat says Lord that she has to make an application online for water connection.
think my learned friend has to, he served me a copy of that.
Serve the copy to the other side also not. But as a matter of fact, not. The applicant has to upload the application through online portal, not Jalanidhi, which will be processed by the concerned panchayat. Similar, not other local authorities, not. Once the applications are uploaded, not, it will be proceeded and water connection will be issued. Not a spot inspection was conducted. On verification, not, it is noticed that there is no panchayat water connection to the entire building. On the other hand, they have depended on the borewell lots. Therefore, lots, once an application is made, lots, we will provide lots the water supply. There is a specific portal lot is created by the government so as to make an application through online.
If I'm allowed to make
But
one
the-
submission, my lordship.
And the order of lots, in the MFA lot, can I also request lot, what is the contempt that is alleged? But the order not passed in the MFA is that not she has to be provided not with this accommodation. And entry not either through gate 3 or gate 4. But can you just persuade not to please see the order dated 11/8/2023. The contempt not is filed against that order. I'm sorry.
Now what, we are for panchayat.
Lord, I am representing the panchayat.
If there is no water connection in the
Lord,
building.
Lord, they are depending the borewell lots, which they have dug. Lots. The owner has dug the borewell inside the premises.
What is your role?
Please, listen.
What is your role?
Lord, my role, Lord,
You will supply the water?
Lord, we are not supplying the water to the entire building. Lord, once they make an application, Lord, we will process it, Lord. They have to make an application, Lord,
Sorry.
through proper channel, through portal, Lord, which is meant for making an application. Jalanidhi portal, Lord, is created by the government, Lord.
If I may be allowed to make a submission, my lordship, ACP South had submitted his report as per my lordship's order, which was dated 30th/9. And in that report, the ACP South has clearly mentioned, it is found, that is on page number 27 of the report.
Where is the report?
The report is not based on.
It
What
is
is-
submitted by the ACP
It-
South,
Yeah.
Not given.
A2. It was submitted on 30th September 2024. Page number 27, that's the translated copy of the ACP's report. And if I may be permitted to read the relevant part, which I want to highlight before this court. May I, sir?
Where is the report? You put your house in order.
Report you have seen? Okay.
23rd January.
My lordship, I'm left homeless, my lordship.
Let the report come.
No, the report is already there
This
before my lordship.
Matter is culminated into order which is last passed regarding the water connection.
Agree, my
Yes,
lordship.
that's my lord's order.
That's
And not she has to, now Lord, they say that she has to apply and obtain not the connection by
My
making
lord.
application online.
One submission, my lordship. Here it clearly says it is found that the house has electricity connection as well as generator connection, but the generator connection has been disconnected by the accused. Secondly, at the moment itself, and it also says the official of the town franchise is provided that this water connection is not there. A line before that, it is written on inspection of the backyard of the house where the water supply to the house through the pipes from the western side is found to be broken. A2 has deliberately broken the pipeline. The report submitted by the panchayat clearly says there's bore water. The whole property is provided water from the bore water. Then why is the accused allowed to break the pipe and get away with it?
Let them find.
Please.
Where is the report?
Let's, we have submitted, my lords.
It is there on record, my lordship.
It's on record.
On page number 27, 26, that is the translated copy, translated portion of the report. On the last line of page number 26,
But report ilwa. Even I don't have the report. But even I don't have a copy of the
it is
report.
served to the other counsel representing, maybe he will give you the file. It,
You don't have a copy of the report, not which is referred to,
They have come on record, my lords. I will serve. It was before they coming.
but I don't have a copy.
So give copy, please. Copy of the report filed by learned additional government advocate shall be served to counsels for the parties.
My
Please.
lordship, one more submission. The Kotekar Panchayat has given me a reply saying that I have to submit documents pertaining to the property. But the Kotekar Panchayat has wrongly mentioned door numbers on accused name. So the application has to be filed by the accused.
In fact, madam, this is the interim order. We will normally not entertain the contempt.
But this is an order which has been violated by him. He wantonly violates all the orders of the court, sir.
Go before.
In my petition, I have mentioned all the orders that he's violated. It's not the first order.
Go before.
Even maintenance, my lordship, 3 crores is pending. He's not paying me maintenance. 3 crores, 17 lakhs is pending as of today. I am left to fend for myself.
So that you go before learned singles and work out your rights.
No, that is my lordship, but right the moment there is an order of the division bench which has been violated by the accused. My prayer before this honorable court is that action should be taken for the disobedience.
Which division bench?
The MFA court has passed an order granting me permission to stay in the house which was supposed to be fully furnished. He has robbed the furniture. He's broken the water connection. He's got his cousin to vandalize my property.
Interim order.
It is a division bench,
order, Lord.
interim order, but it is
The
an order.
MFA is pending. I have filed an application for recalling, but that has to be heard along with the main
The-
matter, what the court has said.
The division bench has
MFA
clearly
is still
said the
pending.
order cannot be recalled. It has to be
As
taken
no-
up to the Supreme Court. If they were so aggrieved, they could have taken it up before Supreme Court, not to file a recall application.
Lord,
They are not party in persons. They are counsels who have studied law and have been practicing for law for so many years. So my lordship is that they're just making me run around in circles, homeless for the last 13 years. Even after getting an order of the court, he has taken off all the furniture, cut off the water connection.
Let them have the report copy.
please.
Short date may be given next week, my lordship.
20th January.
Much obliged.
28th. Please.
My lordship, I'm filing a memo with just the reports that they have given a reply. I have served a copy to the opponents already. Maybe
Filing
taken
the-
on record.
File in the register.
Okay.
Number 45.
Much obliged.
Lords, in this matter, I seek for some time, pray for some time. 1 second,
Why?
sir.
Here for the petition.
A simple matter that they will have to upload the caste certificate and make it accessible to the complainant.
Why are you not uploading?
Lords, there's a government order to file an appeal. This is the reason. It is a caste certificate, and it appears that certain facts were not brought before the honorable court. And this fact certificate caste certificate is restored. My lords, there'll be,
Have you filed the appeal?
no, my lords, not.
Sir, this is not the
Well,
first
it will
round of
have a
litigation.
huge repercussions, my lords, because the benefits with the caste certificate will go a long way. Therefore, my lords, it should not be misused.
Any decision is taken at your level to file the appeal? You're just making a bad submission.
But in the earlier writ petition, liberty was granted to them if at that stage the remedy is available. This is going on for such a long time. They don't take any steps. And they don't allow us to take this thing, certificate.
It can be subject to your filing of appeal if really you are going to file. You have to comply with the order.
Lords, I seek for short accommodation, my lords. It's 3 weeks, we'll get an order, my lords, until then, my lords, because
Not file, not decided to file.
But the accused number 1 and 2 don't appear in spite of service of notice.
The honored additional government advocate, Mr. Kishan, 6 times. By orally stating that the authorities proposes to file appeal against order brought under the contempt jurisdiction. However, when she was asked as to whether any decision is taken to file the appeal, she was entirely at her receiving end. In the circumstances when there is no decision is taken to file the appeal, much less the appeal is filed, much less the appeal is filed, the obligation continues on the respondent 4 and 5 to comply with the direction, full stop. Time is granted for 3 weeks within which
Lords, may I make this submission? Respondent number 4 and 5, they have not, they are not the authorities to validate the certificates, my lords.
It's not the question of validation, my lord. It's only
in
the,
which time the direction to upload the caste certificates will be complied with, failing which the serious view may be taken.
I'm not seeking for any validation. I'm simply,
Yes. We're granting time, so whatever they want to do or comply with the order. 29th of January.
Obliged.
Case number 46.
Hearing for accused, lords. Lords, I kindly pray for 2 weeks of time to comply with the order, lords.
you are not at all compliant, my lord. They are disobeyed the order passed by dishonorable court.
What is the compliance?
Lords,
The
issue-
compliance is, my lord, since 5 years, the petitioner is struggling to obtain the e-khata from the respondent. Respondent has granted the e-khata within a period of 3 months to the other person. I already
you
produced the
deputy
document, my lord.
complying with the order.
Who are you?
I am for the accused, lords. Commissioner.
I'm a deputy.
Yes, lords.
Number 2 or 3, both,
Yes, lords.
both.
I am for the accused number 1, lords. That is Commissioner City Municipal Council.
Commissioner,
City Municipal Council.
PPMP Chamarajanagar.
Chamarajanagar.
Yes,
Please, ma'am.
lords. Lords, we have collected the application, lords. We are complying with the order, lords. It takes some time for the process
Only
to
respondent.
come. Lords, I pray for 2 weeks of time.
Since 5 years, he is struggling to obtain the e-khata, my lord. Within a period of 3 months, they have granted the e-khata to other person. I already produced the document to show that they, without any reason, just to drag on the matter, even in spite of the notice issued by him from this honorable court. And the order passed by this honorable court disobeyed. Simply dodging the matter, my lord.
Respondent herein, there's original respondent 4 was directed by a single judge to consider the representation of the petitioner within stipulated time. The order was passed as back as on 5th August 2024, and the consideration of the representation was to be done within 15 days from the date of receipt of this order. Receipt of the order. Full stop. It is unfortunate state of affairs that the direction, even as the direction is only to consider representation, same is not attended to by the commissioner. And there is a non-compliance of the order. Full stop. Before court takes a stern view, time is granted for 10 days, within which the representation shall be decided by the respondent. The matter shall come up next on board on 20th January, failing which this today is what? Say 20th January, failing which the court will take a serious view of the matter. Put up at 2:30. You comply with this?
Yes,
small?
lords.
Yes.
We'll comply with him.
Put up at 2:30.
Obliged.
Case number 47.
My lords,
Inter-alia,
47, I appear for the complainant, my lords. I have taken steps, my lords. The accused has shifted a residence, my lords.
That is no ground not to comply, shifting of residence.
No, only thing is, there is a trial court, it's still going on. She has shifted the premises. I am unable to know where she has shifted.
You are for respondent.
No, I am for the complainant, my lord.
Complainant.
Therefore, I am only praying that let me serve on the counsel who is appearing before the trial court, my lord.
Learned advocate for the petitioner 6 time to serve the respondents. Time is granted, stand over to 10th of March.
Much
Number 48. To Krishnan CV.
I appear for the proposed respondent number 3, your lordships.
To be taken up on next week, madam.
Hmm?
Next week may be taken up. I will comply with the office objection that is raised.
Learned advocate for the state that
One
will-
submission, your lordship.
will comply with the office objections, stand over to
Your
23rd
lord-
of 23rd January.
One submission, your lordship. I
Yes.
appear for the proposed third impleading respondent, which is the National Commission for Indian System of Medicine. In the meanwhile, I'm not aware of what application he has filed in 2025 because I've not been served with a copy. But I would be a necessary party to the list because it relates to the approval of admissions of students who have
Without
been
counsel, without undergoing counseling.
without counseling. Yes, Your Lordship.
We'll see on that day, madam.
Grateful. I haven't been served with a copy of the writ petition as well, or the writ appeal. So
Because you are so far not impleted, therefore not.
I'm not. Yes, Your Lordship.
How
So if
copy-
the impleading application is allowed, then I may
how
be
copy to
permitted to.
the counsel appearing through video conference.
In the writ appeal as well as the writ petition, Your Lordship.
Yes.
Grateful.
Number 49, Mr. Ravi HK.
My lords, I appear for respondent number 2, my lords.
Along with serial number 70, my lord. It may be
My
called
lord.
along with serial number 70.
Why?
My lords, sir. Both arise from the same order, my lords. Husband and wife have filed against the father of the husband and the father-in-law of the wife, my lords. Senior citizen matter, my lords. They've been asked to vacate the property. Matter was sent to mediation by my lords, my lord.
Taken up with serial number 70.
Yes, my lords.
Yes, serial number 70, please.
All right. So you're here now. Along with 70.
70.
Yes,
All right, along with 70.
my lords, can it be had, my lords, is it possible for it to be had on another date, my lords? I have some inconvenience in the afternoon, my lords. Is it possible to be had on another date?
Very well.
Any short date, my lords? I'm ready in the matter, my lords. Any short date.
20th.
To 20th, 21st, my lords. 20th, I have some difficulty. 21st.
Family dispute, my lord. I request for first week of February, my lord.
First week of February.
My lord,
7th February.
grateful, my lords. Can it be connected and called along with the other matter?
To be listed with number 70.
Grateful. my lords.
Number 50, Shruti Sudhati.
I'm appearing to complain, my lords. I've already served the copy to the advocate, my lords. 1 to 3, they have already filed their wakalat, my lord. The office has raised the objection that we have not paid the copies. Process fee has been paid, but full copy has not been served. Along with that, my lord, I have already served the copy to the respondent counsel also.
Yes, it is so. So we'll argue this.
The date may be fixed for hearing.
Date may be fixed. All right.
Please, ma'am.
At the request of learned parties, come. Who wanted date to be fixed for hearings 10th or to 12th of March.
Please.
Number 51, Mr. Praveen Kumar. 51, Mr. Praveen Kumar.
Sixth respondent.
Mr.
Yes,
PA.
3 and 4, my lords, for BPMP.
Pardon?
We have to file necessary affidavit, my lords. I pray for.
Applies to be filed in 2014 matter. Petition of 2014.
Yes, my lords.
Reply is not filed. Not filed for 10 years. All that petition is not present. We put up on 23rd of 27th of January. You file reply within.
Number 52, Mr. Kushal Kumar Kaushik, 14%. Number 52,
The petitioners in this matter, my lord. Notice was served on the last occasion, my lord. And copies have also been served upon them, my lord. This is a matter concerning the regulation of practice of Asti Visarjan on the banks of River Kaveri. Not seeking a ban, my lord, but just to regulate the practice.
My lord, the office objections have to be complied with, my lord.
My lord, I've complied with the office objections, my lord. The objection was with regards to serving the copies, my lord. I filed an affidavit to that extent, my lord. The respondents were served in.
My lord, it says second set to be filed, second set of the writ petition. Rectification of office objection raised on the affidavit filed by the party in person. Second set is to be filed.
Second set is not filed. Complete set is not. No, then file second set, without which we will not take.
My lord, I filed the second set, my lord. My affidavit was just appraising this court on service of the copies to the respondents, my lord. Notice was ordered. Consequently, my lord, I had served all the respondents, which was not brought to the notice of this court. And appraising this court on that particular issue, my lord, I had filed an affidavit, my lord. I had filed it in 2 sets, my lord.
Second set is filed.
ಫೈಲ್ ಮಾಡಿ.
Incomplete. You have not filed even the counter.
My lord, I pray for some time, my lord.
This
Committee
is-
has been
They
constituted.
want some, how can court regulate all this?
My lord, my lord, the relief that is sought before this court is that, my lord, the practice may be regulated because of the pollution that's happening. And in fact, my lord,
Office shall verify whether the petition is filed in compliance of the office objection, a complete set of papers for the second set.
obliged.
If not, if the second set is not filed with complete papers, the same shall be cured and the office will be complied within 2 weeks.
Obliged.
Upon 17th February.
Obliged,
my
my
lord.
You're a native of this place or not?
Not the place, my lord. I have
Yeah,
visited
you're a native of which place?
Bangalore, my lord.
Bangalore.
Yes, my lord.
Traditionally?
Yes, my lord.
Yes. You should be aware that most of the Hindus, when they cremate their dear ones, when they die,
Yes, my lord.
the asthi is taken and immersed in Kaveri river.
Yes, my lord.
This is a practice that is happening from time immemorial. Whether they utilize the water for agriculture or not, that is secondary. But they necessarily use it. What regulation we can do for that?
My lord, traditionally, my lord, the practice of Asti Visarjana was happening in 2 places. That is Paschima Vaini and Triveni Sangama. But of late, what is happening, my lord, the practice is being spread throughout the entire bank of Kaveri River. And to that effect, my lord, even the district commissioner had issued a notification banning the practice of Asti Visarjana throughout the banks of the river, which is now not been considered, and despite which the
That notification is in vogue.
my lord.
That notification is in currency.
Yes, my lord.
Committee has been formed, my lord. Yes, I'll get the info.
Put in small affidavit.
Yes.
My lord, and one more submission is, my lord, on this very issue, even the Religious Endowments Committee has also written a letter to the commissioner, and committees have been formed since way back 2000 itself, my lord, despite which, my lord, the problem persists.
We'll see what the stand is. Let us see. Yes.
My lord, and there was an interim prayer, my lord. If your lordship allows, I will press it now, or once the
Interim relief, my lord, had refused on 29 July 2024.
obliged, my lord.
Number 53, Mr. Sachin C. Angadi.
My lord, appearing for the petitioner, my lord.
My lords, I am for the respond number 3 and 4. I have filed the wakalat for respond number 3 and 4, my lords.
Let us see what, without saying you want to file wakalat. Illegal construction, bus stand. Bus stand is Muttagi Gram Panchayat. You are for whom?
For respond number 3 and 4, my lords. Chief Executive Officer, Jilla Panchayat and PDO Gram Panchayat, my lords. I have filed the wakalat and parawise remarks also given, my lords. I will file a statement of objection within 2 weeks.
My lord, I am the petitioner, my lord. My lord, no, my lord, the unknown person says, my lord, they are completed the construction, my lord, illegal construction, my lord. They are standard over in completed the circular, my lord. PDO has not at all taken the any action, my lord, and state also not at all taken any action, my lord. After paying the PL also, they are not taken any action, my lord. If the strict order is not passed, my lord, the unknown person will be escape from the clutches of law, my lord. Even my lord, PDO know the everyone, my lord, who has constructed the who has demolished the bus stand, my lord, who has constructed the illegal circle there, my lord. Now, my lord, the Muthi village people are standing in the path, my lord, for the waiting for the buses, my lord. In fact, my lord, the petitioner has filed the complaint, my lord, before the police authority, my lord. Police authority has also not taken any action, my lord.
Heard learned advocate Mr. So and so, who appeared through video conferencing, learned additional government advocate Srimati Neelofar Akbar, who appeared upon service of copy of the petition. Notice is received
No, my lord, it's
in
come up
advance.
the first time. The waiting
was-
service of notice.
Has also heard learned advocate.
My lord, yes, on 4/11/2024. my
Notice
lord,
is
issued.
upon service of notice and learned advocate.
For respond number 3 and 4, my lords. Shiva Yogesh.
3 and 4. Please. Full stop. The present petition style is a public interest petition, where petitioner claims to be the resident of the Muttagi village and further projects himself to be a public spirited person. Paragraph. The prayers advanced in the petition are as in the Roman small 1, Roman small 2, page 15 and 16, bracketed portion. Paragraph. The paragraph stated in nutshell, the case of the petitioner is that at the village where he is residing, particular land was earmarked for bus station, but the bus station is demolished and the another construction is being put up by the authorities in the land. Also, the petitioner wants to direct the authorities to demolish the illegal construction and of the bus stand at the place. Paragraph. The court is not inclined to entertain the present public petition for 2 reasons. Firstly, it is not the domain of the court as to at which place the bus station should be constructed. It is entirely for the executive authorities to choose the site of putting up and constructing the bus station. Full stop. Secondly, whether the construction going on is lawful or not requires a fact-finding inquiry, which cannot be taken in the petition filed under Article 226. Therefore, paragraph. The petition is not entertained. However, the authority shall look into the grievance of the petitioner to the extent as to whether the construction which is being put up at the place in question is illegal or authorized construction. If it is illegal, the authority shall act in accordance with law. Full stop. With above limited observations, this petition is not entertained and stand disposed of. Please.
Pleasure.
My lord, one submission, my lord. Kindly fix the date, my lord, for outer limit of 4 weeks, my lord, for demolish the illegal construction, my lord.
Nothing doing.
Because, my lord, what happened, my lord? They already there one circle has constructed, my lord.
It is over, Mr. Yes.
Number 54, Mr. Harish HV.
So delay of 5 days.
1 week time.
Service is not.
1 week time, my lord, to process
Issue of notice by advocate appellant. 1 week time for what purpose?
pay the process fee, my lord.
Process fee.
Process fee, my lord. Respond number
Process fee is not paid for which
42 and
1 week
43.
time is granted unless the process fee is paid within 1 week. The appeal shall stand automatically dismissed without reference to or order of the court. Yes, next. Please. 55.
54. Seal number 55.
That's 55 minutes. Respond number 2 minutes, respond number 2 is state minutes. Karnataka State Examination Board. And the 3 is Rajiv Gandhi University Health Science minutes. I will serve the MS Devaraju advocate minutes who represented the university before the learned single judge.
Pardon?
2 minutes, respond number 2 minutes, state has to take notice. Karnataka State Examination Board. State.
No, he will not appeal. For KA, he will not appeal. You are
No,
appealing?
it's not K, it's examination board, it's not.
Examination in board.
Not for Rajiv Gandhi University of Health Science, MS Devaraju will appear not. He represented before the learned
No,
single
you
judge.
serve the parties, not like that.
Please.
The counsel of the appellants are directed to serve the respondent parties. Full stop. He may, however, serve the counsels appearing in the writ petition. However, that shall not dispense with the service of notice of the court to the party directly. Yes, put up on 12th of March.
Seal number 56.
Query for the petitioners, my lord.
Nirupakshaya, PH.
Lord, respond number 6 and 9, my lords, are not served, my lord. I may be permitted to take out hand summons, my lord, on respond number
Just notice to the respondent number
6 and 9. my lord.
6 and 9, returnable on 13th March. Service by
Please.
and delivery is permitted.
Great.
Seal number 57.
No, this may be listed on 12th March minutes. This is connected to seal number 55. I will also serve minutes in the similar order may be passed in 57.
Next. The second time compliance. So 57, 58,
Office objections. Office objections also there.
59,
57,
up to 59,
59.
also 60.
59, my lord.
Third time, yes.
59.
3 weeks time is granted in all the
59 subclass 3, my lordship, entry order may kindly wait.
past separate order. 3 months time is
59.3.
granted. Remove the office objection. Dealing with the appeal shall stand. Appeal oblique petition concerned shall stand automatically dismissed without reference to or order of the court. It will be up to 60.
Seal number 60.
Serial number
Third
58,
time.
my lord.
60.
I will do it matter within 1 week, my lord.
You
Matter
can
is-
remove- You can remove within 1 week, but we are granting 3 weeks.
Seal number 60.
60, I'm for the petition, appellant. 2 weeks time may be granted.
Granted 3 weeks in all
Please,
uniform.
Please,
You can remove earlier.
please, I'll do
So
that.
61.
Seal
same
61,
order.
fourth time.
Millard, I have
Once-
complied with the
One second, 1 second. Till number 61, same order, but 2 weeks. Then
that
62.
Millard,
Number 62. So
Art-
council.
Termination of delay is done subject to condition that I deposit 2 lakhs to the legal cell authority. I have done it, Millard.
Which matter?
61, Millard.
So
But still it is appearing as I have not complied. And also stay is granted, that also is done, Millard. IA number 2 they have mentioned.
you complied with.
Yes, Millard. And a
Lieutenant
compliance report also I have filed.
Halima Amin stated that the all of his options complied with and none remains to be complied with. First of the official verify the
And objection number
compliance
4,
and thereafter
4 is for
place
serving on
the
the parties, Millard. I have served on the councils and also because respond number 5 to
thereafter list
17 are
will for
students.
admission.
Even in serial number 60 also, my lords, we have deposited, my lords directed to deposit the
What?
amount, my lords, even 60 also. We have deposited that amount.
60.
Please, my lords. We have deposited the amount, we have produced the receipt.
Stay
before this
also is
court.
granted.
Same order in 60.
Please, my lords. And stay
Same
is
date.
also granted by my lords.
That will be extended. Stay is there is.
Please.
Granted by this court.
Yes, my lord.
Please.
Yes, my lord.
Be
Stay may be extended, my lord, 61 also.
So then why it is listed under the office objection?
That only, my lord. Every time it is coming, fourth time it has come.
So that is the other office objection regarding serving the respondent.
But this is showing even IA number 1, IA number 2, which is complied, my lord.
So same order.
Stay may be
Let
extended.
the office verify.
Stay may be extended.
Yes, next.
The office objection along with council submission, seal number 62,
Hearing for
to
complaint.
Janardhan G, 62.
Here it was only Director of Technical Education. Now it was merged with the Commissioner of Collegiate and Education and Director of Technical Education. my
So
lord. That
62
is
office
the
objection is dispensed with for the time being. The contempt petitions will be listed on 23rd of January. Next.
Number 63,
My lordship, there is a stay order in this case.
Ashok.
Lordship, I am for respondent 2 in this matter, my lords.
This maintainability of this petition to be clarified. What is it?
Maintainability, I have explained them.
The aspect of maintainability shall be examined at the time of hearing of the contempt petition. Therefore,
Yes, my
the
lord.
objection on that count is complied with. The applicant shall be listed on board. Next, on 23rd of
My lord, in
January.
63, may I make a small
Can,
submission, my
can it
lords?
be 20th January, because on the 20th I am flying,
20th January as requested by party in learned party in person.
20th January.
My lords, can I make a small submission as far as 63 is concerned, my lord? This application involves 2 questions, my lord. One is the primacy of IBC over KPID Act.
What we'll do on 20th?
Fine.
Correct. Yes. Next.
Thank you, my lord.
Number 64,
Lord, 64, office notice that, my lord, accused number, why accused number 1 to 3 are made parties. My lord, they are the legal heirs of first respondent in the appeal, my lord. First respondent died during pendency of the appeal. After the death of first respondent, my lord, the A1 to 3 and along with other accused sold the property by violating the court order dated 29/6/2016 in RSC 900 of 2016, my lord.
Yeah.
Since R1 died, hence A1 and 2 being LRs made as part.
But the contempt will not waive the party. We may dispense with the contempt will not lie. We can dispense with the objection, but at the time of hearing, you have to be clear that contempt
Yes.
will not lie if the party is not.
I'll convince, I'll convince, my lord. I'll convince.
Very well. The office objection regarding party is dispensed with. The office may list the contempt petition on 10th of February.
Yes, notice may be ordered to,
Not now.
yes, I'll convince.
number 65, Mr. P. N. Nanja Reddy. 65,
Give some date.
number 66, Mr. B. C. Venkatesh.
My lord, appear for complainant. My lord, there is an office objection, my lord, regarding making my lord as a accused as a person. My lord, in an earlier writ petition, my lord, I have made a commission as a party, my lord, during pendency of the writ petition. It is noticed that, my lord, based on the complaint given by the third party, there is a proceeding is going on before the accused. So by noting, my lord, the pending litigation, it is directed, my lord, the accused to dispose of the appeal within period of, my lord, 8 weeks. Even till today, my lord, the accused has not, my lord, the dispose of my appeal. My lord, pending before the accused.
Listed for office objection.
Please, my lord, that is.
What is the office objection?
My lord, office objection regarding, my lord, why, my lord, the accused was made a party who is not before the, my lord, the single judge, my lord, writ petition.
The same order. For the time being, office objection regarding party is dispensed with to be examined at the time of consideration of the contempt petition. The office may list the contempt petition on 4th March.
4th March, please.
Number 67,
Lord, I, the complainant.
Mr. G. S.
Accused
Venkata
number 2, Lord, is the managing director of the company. Against whom, my lord, the order survives. Therefore, my lord, is also involved in day-to-day affairs of, my lord, the company. My lord, yeah.
Serial number 60?
67.
7. Same order.
And I request for a shorter date because construction is being.
It will be 4th February.
Construction is going on despite the order.
30th January.
Next.
number 68, Mr. Mohammed Samin.
But serial number 68, for
Translated.
the limited relief, my lord, translation of those documents is not necessary, my lord.
Learned
Maybe
counsel
dispensed
said
with.
that the copies, that the documents for which the translated copies are asked for by the office are not necessary.
For the limited relief in this.
In view of the limited relief rate for full stop. while the said office objection is dispensed with, comma, it is directed that if need be, the council should supply the translated copies at the
Please,
time of
please.
hearing.
Please.
The appeal shall be listed on board on 29th of January.
Some short date, please, 29th. Grateful.
Number 69, Alvin Sebastian. 69. Alvin Sebastian.
Nobody is there to give some date. Two matter remains for finally
70.
and for we'll sit at 2:30.
Court officer. Court officer.
Separate board. Recalling. Recalling. Recalling matter.
This, see number 72. Waiting for responding.
But this is a public interest petition. Matter was listed yesterday. Lord, initially, my lord, I came with a grievance so far as fifth respondent is concerned, who was running a pre-university college without following the norms as per the rules of 2006. Lord, the petition was amended. That amendment was allowed, my lord, immediately after filing of the petition. There was a direction to the government to identify how many such institutions are there which are in violation. They have filed a memo pointing out that there are 652 institutions of this nature. And my lord, this honorable court directed notice to all those institutions. Around 61 respondents, my lord, they have come and implemented themselves by filing applications. Those applications are allowed and now they are arrayed as parties to the present petition. Government, my lord, has now filed an additional statement of objection, pointing out that so far as fifth respondent is concerned, he has vacated that place and he has been specifically granted permission because he has complied with the requirement of Regulation 4.2 as amended. But in so far as other institutions are concerned, my lord, the government has to, there is a specific direction on 1/6/2023, directing them to file a statement as to what is the situation so far as the other institutions are concerned. There was an amendment to the rules of 2006.
But the main prayers originally made does not survive.
My lord, the amended prayers, my lord, survive for consideration. So far as fifth respondent is concerned, my lord, those prayers don't survive. Because they have made a categorical statement. That is recorded also, my lord, 1/6.
It is shifted and.
Yes, my
shifted.
lord, they have
We have shifted.
My lord, there should be a cause of action for the writ petition to survive. Now, based on, my lord, the violations of respondent number 5, my lord, they said they filed this writ petition. Now the writ petition doesn't survive because respondent number 5 have shifted their university. Now, for the other prayers to be, my lord, which they are seeking, my lord, for that there should be a cause of action. Just because I make a submission, they cannot hold me and take me to the gallows. 652, let them implead all those, my lord. I wouldn't know who those what those institutions are.
What is the prayer? Restrain the fourth respondent from granting any extension of time to.
Lord, kindly see the order of 31/5/2012 in this writ petition, my lord. Lord, this is not a list between me and the government. I don't know why government is treating this to be a list between me and the government.
How you are taking.
31/5/2012, this honorable court passed an order issuing notice to all 632 institutions, my lord, and pursuant to which some of them have come and implemented themselves. This is a categorical statement made by government on 8/7/2013, which is noted in order of 31/5/2012. So far as fifth respondent is concerned, my lord, from that time they have been saying that they shifted. But that has been recorded many times, my lord, in the order sheet. There's nothing new.
Order 1/6/23.
1/6, my lord, is a direction to the government to file a detailed affidavit. I am referring to 31/5/2012, where, my lord, this honorable court issued notice to all institutions.
Mr. Counsel, Senior Counsel.
Yes.
Look at your prayers. The only prayers, according to you, that survive for consideration are 4B.
Yes.
See,
B.
first of all, this is a country where we don't have sufficient number of colleges. Now, your contention is there are colleges established, but there are certain irregularities in the sense the amount of buildings and all that are not there. Now, look at your prayers.
Restrain fourth respondent from granting any extension of
Why,
time.
if they have not complied with something, they should be allowed to comply and run the institution rather than scuttling down the institution.
Not, but they,
What kind of prayers are these?
it has to be within some kind of a time frame, Lord. Otherwise, they have to, they have amended the rule.
Yes, they are,
Look up.
if they want to grant further time and if they want the institutions to comply with these requirements, and if the institution comply with that, it is beneficial for the society. If we were to grant these types of prayers, it is detrimental to the interest of the society.
Yesterday you are making the same submission.
Yes, my lord.
Lord, my submission is this. The rule underwent 2018, my lord, they amended the rule. That amendment of the rule is challenged before this honorable court. Affirmed, my lord, upheld, affirmed by the division bench. Matter went up to Supreme Court, my lord, the appeal was dismissed. Rule 4.2 is there in the rule book. My lord, either they have to comply with it or, my lord, they may delete it. But, my lord, they cannot have a situation where 2006 rule, they say that please continue to violate it and I will continue to grant you permission to violate.
My lord,
They're open, my lord, to delete that rule itself.
My lord, those rules have also been, my lord, subsequently fresh rules have been issued. They are on 24/9/2024.
If they've deleted the rule, my lord, I have no case. It's not their case that they have deleted for which.
My lord, let them come with a cause of action, my lord.
No, which rule?
Rule 4, my lord,
Where is
it is
it?
called, my lord, I placed it, my lord, it is pre-university education, academic registration, administration and grant in aid,
But this
etc.
was
rules of
amended.
2006. This was, my lord, I have placed the amendments on 23/10/2019. I filed a memo and placed the amendment of 27/9/2018. Not it 23/10/2019.
Now, where is the amended paragraphs?
Lord, I have filed an amended petition on 28/2/2014. Next amendment.
28/12, no?
No, no. There are two amendments, my lord, as and when parties implemented themselves. I have amended, but the amended prayers, my lord, would find in the first amendment also.
So amendment you not file complete petition.
Prayer 4.
Only prayer is inserted, that's all.
That's all. That's what remains.
There is no other.
My lord, other prayers were with regard to respondent number 5, my lord, which they say they have.
All that will pass the orders on 16th.
Obligement.
My lords, I'm appealing for respondent number 5, my lords. I filed a memo stating that I've shifted the college and government has granted
That we
permission.
have seen yesterday.
Please, my lords.
It's recorded also, earlier also.
Much obliged, my lords.
Crossover matters, seal number 16. To Rohit R. Kumar, seal number 16.
Appearing for the complaint, my lord.
Yes.
This contempt is arising out of the violation of the single judge order
15.
dated 20/12/2023. Page number 17, my lord.
Did not entertain. This is just the present contempt
The
petition.
both-
So interim order, the present contempt petition is directed against order dated 20th/1/2023, which is admitted in interim order whereby learn a single judge, during the pendency of the miscellaneous first appeal has directed the parties to maintain status quo in respect of the suit property till the next date of hearing. By very nature of the order, the rights of the parties are not finally crystallized. In the circumstances, the court is not inclined to exercise the contempt jurisdiction under the Contempt of Courts Act 1971, leaving the petitioner to work out his rights and its rights and remedies before learn a single judge, where the main proceedings are pending. No opinion is expressed on the merits. The present petition is now dismissed on the above ground alone.
Cell number 18. Mr. Narasimha Raju.
My lord, I seek short accommodation. My senior is engaged in CH-4, my lord.
Which one serial number?
18.
18. What is the number? Let us see. While reviewing the, while not entertaining the review, while not entertaining the prayer for review of the order, a single judge in his order dated 13th June 2024, disposing the review petition, clarified that the respondent corporation shall consider the case of the petitioners in light of the existing gradation list dated 15th October 22 and 19th October 2022. While considering the case of the petitioners for the purpose of promotion, the above observations are brought under the above observations directions are brought under the contempt jurisdiction of this court by filing this petition. On the bare reading of the aforesaid observation of legal direction, it could be seen that for the purpose of compliance, a single judge has not prescribed any time limit. In these circumstances, it is not possible to conclude at this stage that any of the respondents have committed contempt of the court, much less a willful contempt. The contempt petition as presently filed is not entertainable. But at the same time, the direction of the court should not go on uncomplied with. Therefore, it is provided that the observation of legal directions will be complied with by the competent authority within a period of 12 weeks, failing which the authority shall be exposed to the contempt again. Contempt. The petition is disposed of accordingly.
It's number 19. Mr. A.V. Gangadharappa.
Appearing for the complainant in this matter, my lords. Contempt is against the regional commissioner, my lords.
The contempt is arising out of the disobedience of the order passed.
Returnable on 3rd March. Little earlier, 17th February.
Much.
Seal number 24. So writ petition PAL, Mr. Prakash, HC.
Lots of public interest litigation seeking quashing of annexure L, my lord, which was passed by executive officer, stating that collecting the tax, the land belongs to the panchayat to be mentioned in the name of the respondent number 10, my lord. Annexure L, operative portion of the order is at page 100, my lord.
In the background, some civil litigation.
My lords, they have suppressed the fact that the petitioner number 1, Baswarajappa, had filed a suit along with others. In our additional statement of objections, we have filed the judgment at page 137, seeking a declaration that it is a panchayat property against me. That suit has been dismissed in 2002, 2006. That is conveniently not mentioned in the entire writ petition, along with the additional statement.
That is suit number 242.
No, my lords. He had filed a suit. 242, we had filed a suit against the panchayat for one tamarind tree right over the tamarind tree. But my lords, the petitioner here, the first petitioner had filed a suit along with others bearing OS number 53 of 2002 against me. That is R10.
53 of
2002.
For relief of
My one. My lords, for the relief that the property which belongs to my family is a panchayat property. And that I have no right, or our family has no right title over that. That suit, my lords, has been dismissed by the judgment dated 7/12/2006. That is not even mentioned in the entire writ petition. That your lordships would get the judgment at page 137 in my additional SO. The plaint also is produced.
one 153.
Yes, 137. That is 53. OS 53.
So that is your suit.
That is their suit, Lord,
Yes.
which they had filed against me.
Which is dismissed.
Dismissed in 2006, and that is not even challenged, and they keep quiet and conveniently suppressed in the entire writ petition. Baswarajappa, your lordships would get the Baswarajappa, who is the first petitioner here, is the second plaintiff therein. And the reference there also is regarding the suit relating to assessment number 85. Of my father's brother. The suit was filed against my father's brother. Arten's father's brother. Mallappa is Gangadhar's father. Gangadharappa ಅಂತಾನೆ. Plaint ಎಲ್ಲಿದೆ? In fact, my lords, I don't know whether there is a mistake in the cause title in the suit judgment. In the plaint, it is my father who is the defendant, which your lordships will get at page 112. Plaint, first defendant is H.M. Gangadharappa. The lordships will get 112, man, running page 112. The same suits plain at page 50. In OS 53 of 2002, the defendant is H.M. Gangadharappa. But in the judgment, my lords, I don't know by mistake or I don't know, it's come as H.M. Mallikar. That's the Gangadharappa's brother's name has come.
Where is annexure L? Annexure L which is impugned. What is that annexure? Some order is passed?
My lords, that is where a resolution was passed. My lords, these are what is known as Gram Thana lands in which assessment number was standing in our family's name. My lords, the measurements had to be taken. Our case was the boundaries are much more than what is shown in only the house property was shown. So the panchayat, my lord, resolved that the measurement will take place and we have to pay what is known as value or tax, my lords, for the.
Now this suit number 53 was for same property.
Same property.
No, different property. That is survey number 111, my lord. Your lordship, kindly the judgment which filed with the other side. Annexure A, my lord, see the schedule of
Please see the
property.
government.
Schedule of the property.
Before he
Kindly see,
says that.
lordship. Page,
Plaint
page 30, my lord. In page 30 of the writ petition.
Mr. Counsel, in this petition, which is the property involved?
My lord,
In the present proceedings, which is the property involved?
85, assessment number 85/85, my lord.
Different than this?
Yes, my lord.
My lords, I
Lordship,
can
kindly
only
see.
take to his own suit plaint and the judgment. Please come to page 112, my lords. The plaint government starts in the suit.
112
It starts at 112, my lords, the suit
of the main.
of the additional SO. They have not produced, yes, my lords, in that company. 112, my lords, is the plaint. It commences in the additional SO of OS 53 of. Yes, in that, please turn over to, my lords, para 3 at page 113. It's a long para, but if your lordship kindly come to page 114, the second sentence from top. It is submitted that Panchayat Authority issued an assessment. Your lordship gets that at page 114. It is submitted Panchayat Authority issued an assessment extract in the name of the defendant, assessment number 8182 during the year 1991 and assessment number 85/85 during the year 96-97. Copy of the assessment extract is herewith produced. Except this assessment, there is no document in the name of the defendant, but he has fixed the barbed wire fence to the suit schedule property without having any valid right, title, interest, and much less possession over the suit schedule property to intend to give a trouble to the village members and the plaintiffs, and also to knock off the suit schedule property in a illegal manner. Then, my lords, again at page 115, he refers to the same assessment. 115, that is para 6, which commences from para 6 commences from page 114, but again your lordship should get. At page 115, the last 4 lines of lords, para 6. It is submitted, the above said defendant is a powerful person and his relatives are panchayat chairman and members. By using political and economical powers, he has obtained false and concocted assessment in respect of house property bearing assessment number 85 by 85, measuring 42 by 50 feet and falsely mentioning the boundaries. And that's the suit. Judgment also has referred to the same assessment. And it's against my father. The boundaries, suit schedule boundaries mentioned there are the same boundaries which are for the assessment 85 by 85. Though he mentions in the schedule as survey number, he gives a survey number in the schedule to this suit. But that is considered, and he should have mentioned about this suit, my lords, rightly or wrongly. He suppresses this fact. And this suit is filed against my father, H.M. Gangadharappa. The cause title in the judgment, my lord, appears to be a mistake because the fifth plaintiff's name is shown as the defendant. That's the typographical error which has occurred in the judgment. If your lordship sees the judgment at
Lordship,
page
kindly see
137.
In the 117, the plaint, the schedule, my lord. The schedule and the boundary which has been there in the earlier occasions, they filed a suit for declaration with respect to assessment number 85 bar 85, my lord. The boundary of that particular property and 85 bar 85 and the boundary shown in the plaint as they filed is totally different, my lord. Lordship, kindly see 117 boundaries, your lordships, the survey number 111. The east by same survey number, extent of 28 guntas. West by Panchayat Road, north by Belagara, Shivannaro and Channapasava's house property, south by survey number 2 property. In writ petition page 30, my lord, that is in OS that was filed by the other side, that was dismissed, stating observation was made, your lordship, in the para 22, in 23, my lord. I may be permitted to read that particular line, my lord. The said 28 quintals of land is situated towards the eastern side of the plain schedule of any documents before the court shows that the tamarantry within the boundaries of suit property. On the other hand, the defendant has produced exhibit D1 to D shows the existence of a tamarantry at Gramatana of Alsuru village. Thus, I do not find much force in the argument of say so and so. And at last, my lord, the suit of the plaintiff is dismissed, that he has not established the ownership over it, my lord. And here in this suit filed by them is the survey number 111, my lord. The boundary is totally different when compared to the judgment as earlier it was made out. And they are claiming that it is an ancestral property and they got the same, your lordship. I have produced the partnership deed, my lord, at annexure B, my lord. In the partnership deed, the assessment of 85 and 85 is not shown in this partnership deed as admitted by them, my lord. Even the schedule is not been shown. And even the survey reports, my lord, it clearly says that it is the Gramatana land, my lord. It belongs to the Panchayat, my lord. My humble submission is that the order has been passed by receiving the tax, his name has to be mentioned in the particular thing, my lord. There is no title document. And in order to make that particular granting of that particular land, my lord, section 210 of Gram Panchayat Act, matter, it has to take permission from the government or the Jilla Panchayat in order to make out all these things. Such procedure has not at all been made out. And it is admitted fact, it is admitted thing is this belongs to the Gramatana. They have not disputed the survey report. Survey report you will also kindly see.
Not an admitted fact. I have not.
Survey has been admitted, they have not challenged it. F2, my lord. Translated copy at 65, my lord. Page 65.
Now, coming to OS number 53 of 2002. Which you suppressed.
Yes, ma'am.
It pertains to the same suit schedule property.
It is not pertaining, it is sort of.
Yes, it pertains to the same tamarind tree, 85 or 85.
Yes, my lord. Earlier to that, you
What you did, it went against you. What you did thereafter?
If it is so, my lord, if it is pertaining to that particular property, he himself has filed a suit earlier, my lord, for the same thing. Your lord, you kindly see.
That is different counsel. See, you preferred this particular suit.
That is subsequently it has been filed in the year.
Look, Mr. OS 53 of 2002 was filed by you with regard to the same property.
Yes, my lord.
Correct?
Correct.
Yes, and that suit has been dismissed.
Dismissed.
With the finding given
The
that
finding,
you filed it in public interest, but with regard to other things, that the property belongs to Panchayat has been held in the negative.
in issue number, my lord, the finding.
Just come to page number 140.
140, lord.
Yes, 140 and 141 of their objection statement, original objection statement.
The issues is negative, my lord.
Yes,
Yes.
once you have lost this particular suit, the remedy that was available for you was to file an appeal,
That is,
which you have failed to do so. And you suppress it and come before this court.
one suppression is the other thing, my lord. One more thing I would like to submit your lordship is, they filed a suit in OS number 242 of 2001, annexure A, my lord. My humble submission, the suit itself is for a declare permanent injunction that they have filed. Their finding has been given, my lord, this is Panchayat property that belongs to them, my lord. That was not at all challenged.
But we will not entertain the public interest petition. Dismissed, please.
Allah 200, my lord, may I make a submission, section 210 of
What's
Gram
his
Panchayat
focus?
Act, my lord, they will have to take permission from all granting and other things, my lord. They only am based on the, even the order has been passed, even.
Rival civil litigation itself, and more particularly the issues in the suit and the finding thereof, is entitles you to file a public.
Allah, my humble submission is, my lord, why the public interest litigation have been filed is, it is the public property, my lord, that's why we have filed a suit and petition has been made out. It is not a personal interest over this particular property, my lord. When it is the survey report and everything states, in the absence of any document produced by the other side before the authority showing that they are the owners of the property, that procedural aspect under section 210 to be followed, that was not done, my lord. That is only sufficient.
We'll deal with, yes.
Till number 28, the Amritesh MP. 28.
Yes. Still it is there, anything is there? 28. Demolish the taluka, nobody is there. Keep it on 22nd.
22nd. Number 32. Mr. Amritesh NP. Number 32. CPA.
Write down earlier matter and this. None was present in the first half. Full stop. Also in the second half. The counsel was not present. The petition could have been dismissed for want of prosecution. However, in larger interest of justice, turned out 22nd, both.
This is number 42.
Appeal for the respondent.
Sir, Dharmaraj Desai.
I am the husband. I live in USA. When I had come here, the proceedings for dissolution of the marriage are pending. I had filed an application to see my two children who are presently in the custody of my wife. On that application, an order came to be passed by the trial court to permitting me to see my children on every Sunday for about an hour. What is the page? Page 55.
58.
58 is the relevant portion. For 1 hour on every Sunday from 10 a.m. to 11 a.m. This, unfortunately, the respondent did not comply. Therefore, I had to file a habeas corpus petition in which, there was a direction by this honorable court directing the children to be produced. Then I had some visiting, I interacted with the children. Again, thereafter, there was non-compliance. Finally, the court now, I went back to USA. All that the court now says is, at least through WhatsApp, on every alternate days, whenever the children are free, without affecting them, you allow the father to see the children, which is at page 101. All that I am requesting, I don't think this should be really an adversarial litigation. All that I am requesting is, allow me to see my children at least over the video call and express my affection towards them. Of course, the main proceedings are pending between the parties. Whatever happens there, we will accept it.
Yes, madam.
May I submit, my lord? Will ultimately kindly see the order passed on the two orders my learned friend says that I have violated. The first order is dated 6/4/24. It says, contact the children till appearance of the respondent. Will ultimately kindly see my counter. Page 8.
Page 8.
Page 8 of my counter, my lord.
Page 8.
8. Para 2 in the page 8, my lord. Lordship got it, my lord?
Page 8. Please. No, there's nothing. Till the respondent appears in the
Only till the appears. I appeared. Then the matter ended there. Thereafter, the habeas corpus was there. He was directed to see. He met my children for 1 hour. The matter ended there. Habeas corpus was disposed of. He was directed to file an application if he wants a further order. Now, he has filed an application and the order is reserved till 24th.
But all that I will put it across in matrimonial matters, my lord, where the father wants to put it up to children. If my learned friend says, learned senior counsel says, such hyper-technical please.
What is the age of the
children? Are
There are 2 years and 4 years. And he says he must
5
be
and
allowed
4
to
years.
speak. 2 years and 4
How
years.
can the mother, my wife, make this into a prestige issue of prestige? All that I want to see is my children over the video call. Enforcement, how to do it. But these are all matters, lords, where.
What is the difficulty? Why mother is not permitting the video
Well,
calls?
There was no difficulty, my lord. What happened was he filed an application and we filed our objection. Order is reserved to 24/1 of this month. Yeah, and then mediation, which was referred JNWC, he said, I will not come. I will not appear before the mediation. So the court heard the matter and reserved the matter for orders on 24th. The matter is pending there. He can always come. I don't say. But he says some foreign, phone number of America. He says, I want to call. My client is residing in India. She does not have that phone number. He does not know which phone. And what happened, during when he was there in America, when the child was 30 days, he filed a complaint and allowed, my client was taken to custody by the American court. She had to take rescue, come back to India. This is how can children 2 years and 4 years. Where is the question, anytime he can see. I have never objected. He can come and see the children. Now the court is ordered for 24th, when he can come and see. I have no objection. I never objected. He says, allow me to speak to the children. That is the order. 2 years and 4 years, how can I say, compel my children, give the phone to them, whether they will be willing to speak or not, I am not aware. He is in America. Now he says he wants to speak, I have no objection.
So since the passing of this order, anytime the talk has taken place?
No, in fact, I have written mails, therefore, just to show. Now, this has become, Lord, something where the wife, I do not know, Lord, these are all human rights, Lord. Father, if he is not allowed to see his children, Lord, and in spite of a court order, Lord, just may kindly see, it's in spite of a court order.
Children serve 5 years and 3 years.
5 years, boys, Lord, they are boys. And Lord, they should also have the benefit of seeing their father, Lord, for a better growth. Mother cannot, Lord, treat them as their property. In fact, Lord, children, I am told, Lord, were really affectionate.
They are studying, madam.
In Bangalore, in a school they are studying. Both of them are in a small 2 years, one, not going to the school. Another child, only 4 years. I have no objection. Anytime he can come and see. I have never objected. Now he's in America. Where can he see, my lord? He says, allow me to speak to them half an hour in a phone. He says, give the phone to the children. Which
So if-
phone, my lord?
If the mother is not objected, let the father.
Yes, my lord, let him come, my lord. Anytime he can come and see. I have never objected.
You can call, you can have a video call on this.
Yes, not video call only. All that I'm requesting is a video call itself, not
Yes,
physical.
which phone? Your lordship, kindly the phone number. It is an American phone. He says
Don't
America,
understand
which
what
he
my
has a
learned friend
phone.
is saying. This is what. No.
I have no objection. Let him call anytime and let him
He may
talk,
talk
my
through
lord.
American phone, but you talk in Indian language.
I don't have that phone. He says I am
No,
calling
I
with
don't know,
that phone.
American phone, Indian phone, all phones. I mean, what is this? No, that's right.
No, number of America, my lord,
No,
not
American phone
India.
or Indian phone, I don't understand. What is the difference between?
You also don't.
Phone number.
So
I
But
don't.
if the learned senior counsel now says, no, she doesn't have any objection for me to make
Whichever
a-
may
I
be
have
the
never
phone,
objected.
madam, whichever may be the phone, but the father will call on Saturday.
Yes,
Yes,
Saturday,
well,
this
let him
Saturday.
tell in which number he wants to call, my lord.
This
You
Saturday, at
can't
what
say
time?
America, my lord, I will not renew my phone. I can't pay in the dollars.
At Indian time,
That
11
phone.
o'clock, 12 o'clock in the
No,
morning, 11 o'clock.
this Saturday, Indian time, 11 a.m.
Correct.
Yes, tell me in which number you want to call. To which
No,
number?
no, whatever number right now, Lord, let my learned friend Lord give it. I will just note it and Lord will.
We will record in the order the number.
Yes, yes. The number, let my learned friend give the number, will get. Yes. Saturday, 11 a.m. Indian time, we'll call. Let them give the number.
So she is saying that he doesn't have his number to lift the phone. That's his.
No, I will say, Mrs. Pramila Nesri will WhatsApp her the number of the.
Well, I will give my lord. Madam, my client is a working lady. 11 a.m. he says, I will keep my lord. Somebody will be there, will give the phone. I do not know how the 2 years old can hold the phone and talk. I do not know. I will give the phone, my lord. If they talk, I have no objection. 2 years old, my lord.
My mother will hold the phone and.
Mother, she's a working lady. My lord, she's not earning.
Whatever time is convenient to.
I will
Whatever time is.
give the phone, my lord, to the hands of the children. I have no objection. I will give the phone
How
to the
can
hands of the
2-year-old
children.
hold?
I will give the phone to the hands of
All
the
right,
children.
But she said Saturday it's working for
Then Sunday.
Sunday we'll call. Sunday,
Yes.
11 a.m. Indian time. Call.
Yes, my lord.
Please.
You can hold the phone on Sunday, madam. Mother will be there.
I have no objection. I only brought your lordship notice. However, I can compel the child to speak. I can hold the phone. I can't compel them to speak.
We will appoint you as a court commissioner to execute the.
Yes, my lord. I will not my appointment. I have no objection. The commission can hold the phone.
No,
Certainly, my lord.
You have faith in madam. We don't require anybody else.
Anyway,
Madam,
this
advise your client, madam. This is husband and wife straining of their relationship. They should learn to part as mature adults. The kids require both father and mother.
That's correct.
Don't make them a bad citizen of this country. If you deprive them the love and affection of one of the parents, they will grow up to be bad citizens. You need to understand that. You do fight. You determine your rights. That is a different thing altogether. Now, after all, the husband is asking that he should talk to them over telephone. Make it available. Both of you should not be poisoning the mind of the child. You need to understand that. It is very important.
have I ever denied, my lord? Is it this case I have denied? I have never denied. In fact, my lord, on the last date, I took the children, he spoke for 2 hours. Why, my lord, why should he make an allegation? Then I am not denying.
Email accounts.
I am not denying. If I have denied, I can understand. I have never denied. On the other hand, he took my client to the jail. In America, he put her behind bars. depriving me from this when child was 30 days old. Hardly 30 days. He put my client in bar in jail in America. I had to rescue myself, call my parents and come out. I have never done it. Anyway, my lord, your lordship is fixing Sunday. Here, let him talk.
The present contempt proceedings at the instance of the petitioner father arise out of order dated 6/4/24 passed by learned sixth additional principal judge in the Guardian and Ward petition number 135/24. Wherein an interim order is passed inter-alia permitting the petitioner father to speak through WhatsApp public video call between 5 to 6 p.m. every alternate days for 15 minutes. The respondent mother is directed to coordinate with the petition. Full stop. They both are male child?
Males.
The children are 5 years and 3 years. Sons born out of the wedlock of the parties. Application. It is unfortunate that the order was passed as late as on 6/4/24, in which, in addition to the above direction, the father was also given visitation rights, which could not be availed as the father had to leave the country, it was stated that even the directions to have the WhatsApp video call has not been rectified for all these months. In course of the hearing today, paragraph, learned senior advocate Mr. So-and-so is right in complaining that the father has a human and natural right to talk to his minor sons. Full stop. It is also to be observed that the child will develop lopsided. Both mentally and emotionally, unless receives the love and affection of both the parents, that's mother and father. Full stop. For a child of the year 5 and 3 years, as in the present case, a father talking to the father or mother talking to them is also a part of the welfare of the child, and such discourse is necessary for development of the child in the process of his or her growing. Paragraph. Learned senior advocate Ms. Naisargi, appearing for the respondent mother, agrees that the father will be permitted to talk to both the children named so and so.
Stavya, Lordship, Stavya Nayak and Vedit Nayak.
Little loud, give name. On Monday, permitted, fathers will be permitted to talk to both the sons named so and so. It is agreed that the process of permitting the father to talk on video call shall start.
Sunday.
First such talk to be conducted on, this is which, 12th of
12th. Yes.
January. Full stop. Learned senior advocate for the applicant father stated that the father will call sharp at 11 Indian Standard Time to the mother from a mobile number.
He'll give it.
I'll produce it.
Give the number, full stop. Learned senior advocate for the mother assures the court that the phone shall be received by the mother and the mother will permit both the child to talk with her father. Full stop. The talk may last at least for 15 minutes or until the children may talk with the
Yes.
father. Full stop. Parties are directed to cooperate in the implementation of this order. Stop the proceedings next on 22nd
Please.
January.